Yes, Mr. Jeremy, just so that everybody knows, including in particular the shorthand writer, we will be reserving our judgment and decision in this case, so it's unnecessary for her to remain. So far as timing is concerned, we have read the papers with which we've been provided, which are quite extensive, but we have been provided with a reasonable amount of time to do that. So you can assume that we've done it. And we do need to get through the hearing today, so you need to, both sides need to tailor what they say with that aim in mind.
Thank you. My Lords, as you know, I appear for the appellant, assisted by my noting junior, Miss Morley.
Yes.
The respondent is represented by my learned friend, Mr. Perry, King's Counsel,
yes,
and his junior, Miss Ailes.
Yes.
Both having been instructed since the elevation to the bench of both leading prosecuting counsel and junior prosecuting counsel. This case comes to this court by reference of the Criminal Cases Review Commission in August of last year. The trial took place at Oxford Crown Court in the summer of 2019. That trial was followed by, so far as the appellant is concerned, an unsuccessful first appeal in March of 2021 before the then Vice President of the Criminal Division, an unsuccessful application for a rehearing of that appeal after the issuing of the draft judgment and before publication of the final judgment, an unsuccessful application for leave to appeal to the Supreme Court in June of 2021, and an unsuccessful application to reopen the appeal before the then President of the Queen's Bench Division in March of 2022.
Yes.
My Lords, I will be sticking fairly closely to a speaking note that contains all references, and it was designed with a view to providing it to the court if that would assist at the end of the oral submissions.
Thank you. It would, I'm sure.
I'd like to start, if I may, by taking you to the directions that were given to the jury in this case. I'm very conscious of what your Lordship has said about having read the papers, but I would like to read, insofar as they dealt with causation, the directions given to the jury in this case. The third version is at item 9 of the digital case system. It's at digital case pages 295 and 297, the relevant bits, although, as I say, my note will contain all references, and I won't therefore continue to give them orally unless you require me to do so. Insofar
it will help us to follow what you're saying while you're saying it, if we're looking at the right document. When I say looking at the right document, we very much welcome the opportunity with your assistance to look at the key documents in the case.
Yes.
But we don't need to go through all of them.
Well, my Lord, thank you. I'll obviously take my lead on a case-by-case basis from you.
Thank you.
As far as the, as I say, directions relevant to causation, they're at page 22. That's the internal pagination of the directions, where paragraph 4 reads, "An act causes the death of another if it is more than a minimal cause of it. If it is proved that with intent to kill, Ben Field in person gave Peter Farquhar drink, then even if Peter Farquhar agreed to drink it, it would be open to you to conclude that the giving was a cause of death, unless Peter Farquhar's decision was informed in that he knew that the drink being offered him was intended to cause his death." And then over to page 24, internal pagination of the directions, under the heading Count 1, that's the murder count, the ultimate questions bearing in mind all my relevant directions. Question 1 refers to mens rea, and then question 2 reads, "Have the prosecution made us sure that with that intent then Field did one or more of the acts alleged by the prosecution, i.e. in person giving Peter Farquhar drink and or Dalmane and or suffocating him, which were a more than minimal cause of Peter Farquhar's death. If you all answer yes, verdict guilty. I hope your lordships will forgive the homeliness of the submission that I'm about to make, but those directions don't look right. And they don't look right because they don't ask the jury in the form of an open question to determine whether Field caused Mr Farquhar's death. I'll refer, if I may, I'll use surnames if I may, with no discourtesy intended. Because they don't require the jury to decide whether Field had caused Farquhar to drink the whisky that caused his death, because they don't require the jury to decide that Farquhar had been forced or tricked into ingesting the substances that caused his death. To convict of murder, the directions merely required the jury to be sure that Field, in person, gave Farquhar whisky and or Dalmane, and that Farquhar drank in ignorance of Field's intention to cause his death. On these directions, Field would be guilty of murder if he gave Farquhar anything, that Farquhar did anything with or to, so long as the thing that Farquhar did caused his death. And if these directions are correct in law, then any victim who was ignorant of a defendant's true intention would be incapable of acting autonomously and agreeing or consenting to anything of their own free will. These directions look perilously close to an invitation to convict Field of murder because of his mens rea alone, because it could not be argued, and it was not argued, that Farquhar might have drunk whisky given to him by Field if he had known of his intentions. These directions look wrong because they are wrong. And the reason why they are wrong can be identified by the asking and answering of three questions. Question 1. What was the act which was the proximate cause of Farquhar's death? The answer to this question is that the act of ingesting whisky and Dalmane was the proximate cause of Farquhar's death. It was not the act of giving those substances to him. As stated in Kennedy, the act of giving whisky and Dalmane could not have harmed Farquhar in any way, let alone caused his death. It was Farquhar's act of ingestion which was the proximate cause of his death. Question 2. If the act of ingesting whisky and Dalmane was the proximate cause of Farquhar's death, then could Field have caused Farquhar's death? The answer to this question is yes, for the reasons explained by Hart and Honoré. If Field had caused Farquhar to do the act which caused his death, the ingestion of whisky and or Dalmane, then he, Field, could have caused his death. To cause Farquhar to ingest whisky and or Dalmane, Field would have had to have done more than persuade Farquhar to ingest them. Because if he merely persuaded Farquhar to ingest them, the act of ingestion would still have been Farquhar's act. To have caused Farquhar's death, Field would have had to do or say something that caused Farquhar to ingest whisky and or Dalmane, and that rendered Farquhar's act of ingestion less than fully voluntary. Because only if Farquhar's act had been less than fully voluntary would it have been Field's act and not Farquhar's act that caused the ingestion of whisky and or Dalmane. I use the word fully voluntary, or voluntary. It's regularly used in the textbooks and authorities as a shorthand for free, voluntary, and informed, or indeed it's formulated in different language in different places. But so that the court understand it's a shorthand. If Field had done or said something that caused Farquhar to ingest whisky and or Dalmane, and that rendered Farquhar's act of ingestion less than voluntary, then he would have started a chain of causation going that had two links or acts. The first link would be the act by which Field caused Farquhar to ingest whisky and or Dalmane, and the second link would be Farquhar's act of ingestion, which in turn caused his death. Hart and Honore describe the ways in which the act of the victim could have been both caused and rendered less than fully voluntary as being by the use of force, duress, or deception, with the deception being as to the nature of the act. The example given by Lord Bingham at paragraph 12 of Kennedy is of the defendant putting a noxious thing into food which the victim is about to eat, and of the victim eating the food in ignorance that he's done so. The importance of the ignorance of the victim in Lord Bingham's example is that only if the victim had been ignorant of the presence of the noxious thing would the ingestion of it have been other than his own voluntary act. This would have therefore been a deception as to the presence of the noxious thing, which changed the nature of the victim's act. It was not a deception as to the defendant's intention, which, although it would be relevant to the culpability of the defendant, has no relevance to the voluntariness of the victim's act of ingestion. So, applying these principles to the facts of this case, to have caused Farquhar to have ingested whisky and or Dalmane, Field would have had to have forced or threatened Farquhar to have done so, or else deceived him as to what he was ingesting. The third question. Was there evidence that, on the night that Farquhar died, Field caused him to ingest whisky and Dalmane, and that his ingestion was not fully voluntary? The answer to that question is no. And that can be demonstrated by what the prosecution said about its case in opening and by the summary of the evidence provided in the summing up. At paragraph 10.7 of the opening note, that, my lord, is item 15, GCS page 381. At paragraph 10.75 of the opening note, which was just about the only reference as to what it was suggested Field had done to cause Farquhar's death that night, this was said. In other words, Farquhar had taken or been given more sedatives that evening. He had drunk or being encouraged to drink a quantity of alcohol. The transcript of what was actually said in opening, and that has been obtained by the CCRC, shows that the prosecution went further. I'll take, when I develop all of the reasons why the answers to these questions are as I suggest, I will develop that subsequently. This is, I hope, a helpful introduction. But I will then take you to the transcript of what was said. But for these purposes, the transcript shows that the prosecution accepted that on the evidence, Farquhar could have taken the Dalmane voluntarily and at most had been given and encouraged to drink the whisky. By setting out its case in this way, accepting that Farquhar could have drunk whisky and taken Dalmane of his own volition, even if he had been encouraged to do so, the prosecution was acknowledging that it could not prove that Field had caused Farquhar to ingest whisky and or Dalmane, and so could not prove that he had caused his death. I'll return to, as I've said, to each of the questions. But these were the three questions that confronted the prosecution if it wished to prove that Field has caused Farquhar's death as a result of his ingestion of whisky and Dalmane. But instead of accepting the answers, the prosecution changed the questions. Instead of accepting that there was no evidence that on the night that Farquhar died, Field caused him to ingest whisky and Dalmane by means that rendered his ingestion less than voluntary, the prosecution changed the questions to ones that the evidence appeared to be able to answer. It avoided the difficulty of being unable to prove that Field had caused Farquhar to ingest whisky and or Dalmane by falling back on the act of giving whisky and or Dalmane as the act which caused Farquhar's death, an act that, as explained in Kennedy, could not have caused Farquhar harm, let alone his death. Field's giving of whisky and or Dalmane to Farquhar could not have caused Farquhar to ingest the whisky that he gave him any more than it could have caused Farquhar to drive his car if Field had handed him his car keys. Or for that matter, it could have caused the weak swimmer to swim if no false promise of rescue had been made. An undisclosed intention cannot be causative in the way that forced ingestion or ingestion under duress or ingestion as a consequence of a deception as to the contents of a drink could be causative. By bringing a case based on the act of giving whisky and or Dalmane rather than on causing the ingestion of those substances, the prosecution obscured but did not cure its inability, the inability of the evidence, to prove that Field had caused Farquhar's death by means of whisky and Dalmane. Obscured because, as the exchanges between judge and junior prosecuting counsel at the time of the jury questions show, the reliance on giving as the act which caused death led Mr. Justice Sweeney to the belief that causation could not be an issue in this case. These exchanges are highly significant, and I would like to return to them in much more detail. The references, transcript is at item 5 of the DCS, and the relevant pages are DCS pages 173C to D. But for the moment, if I may, I'll just read to your lordships the relevant 6 lines or so where the following exchanges take place between judge and junior prosecuting counsel. Neither leader was present at the time of the jury questions. Mr. Rokes, who was junior prosecuting counsel, this is in the context of the questions. My lord, yes, the direction includes it is open for them to convict that giving him the drink was a cause of death. Mr. Justice Sweeney, yes. Rokes, I don't think there is, Mr. Justice Sweeney. Well, there can't be any dispute about that. Rokes, there simply can't, on the evidence in this case, that any giving of the drink was a cause of death. It simply must have been. The question for them, and he goes on to explain what the question for them, the jury, was. Judge and prosecuting counsel, in that short exchange, were there expressing the shared misconception that had been created by the way in which the prosecution had put its case. The misconception that the giving of drink must have caused death so that causation could not be an issue. Not only could it be disputed that the giving of drink was a cause of death, but on the evidence, the giving of drink could not have caused Farquhar's death because there was no evidence that Field had caused Farquhar to ingest the whisky and or Dalmane that caused his death. Yet Mr. Justice Sweeney, looking at the issue of causation through the lens of giving whisky and Dalmane, instead of the lens of causing the ingestion of those substances, and so believing that causation could not be an issue, in his legal directions, effectively invited the jury to conclude that the giving of drink had been a cause of death by directing it that it would be open to you to conclude that the giving was a cause of death, so long as Farquhar had drunk while ignorant of Field's intentions, something about which there could be no dispute and was no dispute. So there was, from the outset of this trial, a failure to identify correctly the act that caused Farquhar's death, and therefore, as a consequence, to identify what the prosecution had to prove in order to establish that an act of Field, as opposed to an act of Farquhar, had caused the latter's death. And everything that has gone wrong in this case stems from that failure. It led to the misconception that causation, which couldn't in fact be proved, was not an issue. It led to the misdirection of the jury. The result of that was that Field was convicted of causing the death of Farquhar by whisky and/or Dalmane when the evidence did not prove that he had done so. He was convicted of doing something which on the evidence he simply did not do. Fourthly, the failure to identify correctly the act that caused the death contributed to the contradiction and confusion which were the hallmarks of this court's approach when dismissing this appeal in March of 2021. I'm referring to the changes made between draft and final judgments. And finally, the further consequence of this failure to identify correctly the act that caused death has led to the respondent, in its respondent's notice, making as its central submission an argument that fails to address the true issue, that misses the mark. Misses the mark because the premise of the respondent's argument is that the act of giving whisky and/or Dalmane was an act capable of causing death, which started a chain of causation going, so that the only question raised in this appeal is whether Farquhar's act of ingestion, while ignorant of Field's intention, was fully voluntary and capable of breaking that chain of causation. Once the act that caused death, the act of causing the ingestion rather than of giving, is identified correctly, and it is recognized that there is no evidence that Field caused Farquhar to ingest those substances, then it is plain that the premise on which the respondent's central argument in its respondent's notice is false, and the act of giving could neither have caused death, it couldn't have caused the act of ingestion, it couldn't have started a chain of causation going. In making this as its central argument in the RN, the respondent perpetuates the error that has been made in this case from the beginning. It bypasses the requirement that the prosecution prove that Field caused the act of ingestion, which caused Farquhar's death, just in the way that the entire prosecution case bypassed that question by fixing on the act of giving rather than of causing the ingestion. My Lord, may I conclude my introductory remarks by dealing with the relationship between the four grounds of appeal. In order to prove that Field had caused Farquhar's death on the night of Sunday, the 25th of October 2015, by whisky and/or Dalmane, the prosecution had to prove two things. Firstly, that Field caused Farquhar to ingest those substances, and secondly, that Farquhar's act of ingesting them was not free, voluntary, and informed, voluntary for short. Under ground one, it will be submitted on the evidence in this case, it was not possible for Field to have caused Farquhar to have ingested whisky and/or Dalmane merely by giving those substances to him. Under ground two, it will be submitted that the respondent's argument that Farquhar's act of ingestion could not have been free, voluntary, and informed as a matter of law because it was not informed as to Field's intention, and so did not have to be left to the jury to determine, that argument is not only wrong, but the opposite is true. It will be submitted under ground 2 for the reasons given in the authorities on the effect of deceit on consent in the context of sexual offending. Field's deception of Farquhar was not capable of rendering his ingestion less than free, voluntary, and informed as a matter of law. It follows that, from that resume of grounds 1 and 2, that each of grounds 1 and 2 are capable of rendering the conviction for the murder of Mr Farquhar unsafe. For convenience, I have referred so far to the giving of whisky and or Dalmane, because that was how the case was put. In fact, the written legal directions, to the extent that they touched on causation, did not even refer to Dalmane. And that omission and the consequences of it is the subject of ground 3. Ground 4 addresses the inadequacy of the direction on minimal cause. While grounds 3 and 4 address errors that are less profound than the errors addressed in grounds 1 and 2, that is only in relative terms. The errors identified in grounds 3 and 4 are each of them, of themselves, capable of rendering this conviction unsafe. Can I then turn, my lords, that's the end of the introduction, can I turn to ground 1? As I said, under ground 1, it will be argued that on the evidence in this case, it wasn't possible for Field to have caused Farquhar to have ingested whisky and or Dalmane merely by the act of giving. And I'll also expand on the reasons why the 3 questions that I identified in the introduction should be answered in the way suggested. So the first question, what was the act which was the proximate cause of Farquhar's death? The answer is that it was the act of ingesting whisky and Dalmane rather than Field's act of giving. And that derives from what was said in Kennedy. Lord, there are, I think, in the digital case system, 2 copies of Kennedy. I'm going to be referring to the one at item 18, and in particular for the quote that I'm just about to read to your lordships. This is at paragraph 7 of the judgment, page 274 of the judgment. Kennedy is also found at item 66 of the DCS. And the quote from the judgment is this: "But the act of supplying without more could not harm the deceased in any physical way, let alone cause his death. As the Court of Appeal observed in Dalby, the supply of drugs would itself have caused no harm unless the deceased had subsequently used the drugs in a form and quantity which was dangerous." The critical importance of identifying correctly the act which caused death was common to both Kennedy and Field. Kennedy was a case of unlawful act manslaughter, and so it was concerned with the unlawful act on which the manslaughter count was founded, whereas Field was concerned with the act which caused death on which the murder count was founded. It was the failure to identify the act on which the charge in each case was founded that led to what Lord Bingham called in Kennedy the difficulty and doubt. At paragraph 26, the final paragraph of the judgment, it's page 279 of the judgment, Lord Bingham said, "Much of the difficulty and doubt which have dogged the present question has flowed from a failure at the outset to identify the unlawful act on which the manslaughter count is founded. It would focus attention on the correct question and promote accurate analysis of the real issues if those who formulate, defend, and rule on serious charges of this kind were obliged to consider how exactly in law the accusation is put. With the substitution of the words, the act causing death on which the murder count is founded, for the unlawful act on which the manslaughter count is founded, those words could be said of the case of Field. Having identified the act which caused death, the next question, the second question, was if the act of ingesting whisky and Dalmane was the proximate cause of Farquhar's death, then could Field have caused it? Yes is the answer to that question. But to do so, the prosecution would have to prove that Field caused Farquhar to do the act which caused his death, ingest whisky and Dalmane, and that Farquhar's act of ingestion was not wholly voluntary. This answer derives from both Kennedy and from Hart and Honoret's causation in the law. Considering Kennedy first, item 18 of the DCS, at paragraph 9 of the judgment, when considering section 23 of the Offences Against the Person Act, the relevant charge in that case, Lord Bingham says, the substance of the section creates 3 distinct offences, and then number 3, causing a noxious thing to be taken by any other person. The same factual basis for the prosecution in this case. And at paragraph 12, Lord Bingham goes on, offence 3 covers the situation where the noxious thing is not administered to the victim, but taken by him, provided the defendant causes the noxious thing to be taken by the victim, and the victim does not make a voluntary and informed decision to take it. If D puts a noxious thing in food which the victim is about to eat, and the victim, ignorant of the presence of the noxious thing, eats it, the defendant commits offence 3. The word "and" I emphasised in that extract to make the point that 2 things have to be proved, both that the defendant caused the victim to take the noxious thing and that the victim's act in taking it was not voluntary or informed. The judgment continues at paragraph 14. Thus, the defendant is not to be treated as causing the victim to act in a certain way if the victim makes a voluntary and informed decision to act in that way rather than another. There are many classic statements to that effect, and as I know your lordships have read, Lord Bingham goes on to quote from Professor Glanville Williams, I may suggest reasons for doing something, I may urge you to do it, tell you I will pay you to do it, tell you it's your duty to do it, my efforts may make it very much more likely that you will do it, but they do not cause you to do it in the sense in which one causes a kettle of water to boil by putting it on the stove. Your volitional act is regarded within the doctrine of responsibility as setting a new chain of causation going, irrespective of what happened before. And Lord Bingham goes on to quote from chapter 12 of Hart and Honoret's Causation in the law, the free, deliberate and informed intervention of a second person who intends to exploit this situation by the first, but is not acting in concert with him, is normally held to relieve the first actor of criminal responsibility. That quotation from Hart and Honoret is taken from chapter 12. The court has 2 extracts from Hart and Honoret taken from different chapters. Those are at item 13 of the digital case system. Those, my lord, I would ask you to turn to because they are important and I can't simply extract the relevant parts from them.
So, item 13?
Item 35, my lord.
35, sorry. Yes.
The first section in the short 2 extracts that you have, the first section, which is book pages 326 to 329, comes from chapter 12. But then the next section, book pages 363 and 364, comes from chapter 13. In those short extracts, not included is the title of chapter 12. But I have the book and can tell you, lordships, that the title of chapter 12 is simply Criminal Law Causing Harm, whereas the title of chapter 13, from which the second extract is taken is, which is visible in fact on the extract, criminal law causing, inducing, permitting, helping others to act. And as far as chapter 12 is concerned, again, with apologies that this isn't part of the extract, but this is what the 3rd to 6th lines of chapter 12 say. The present chapter deals with causing physical and economic harm, the next with interpersonal transactions such as causing, inducing, helping, or permitting others to act. And so it is chapter 13 that is of more direct relevance to the facts of this particular case. As to how another person can be caused to act, Hart and Honore put it this way, and this is part of the extract the court's been provided with, at the bottom of page 363 and the top third of 364. But it is also clear, 3 lines from the bottom, it is also clear that when offences are defined either by simple verbs like killing or in causal terms causing death, the required causal connection exists in certain cases where the harm is brought about by the act of another, viz. Where it can be said that accused caused the second act. This is the case only where the accused intends the intervening actor to do what he does and the intervening actor's conduct is not wholly voluntary. Hence, a person may be guilty of homicide by inducing another to kill or to do an act dangerous to life, which in fact results in death, if the means used amount to coercion, deceit, or the exercise of authority, but not if mere persuasion of an adult responsible person is employed, or if the accused's conduct operates without his intending it as a reason for the other's act. In a similar way, and this opens up the relevance of the case of Anne Moreton, in a similar way, where suicide is not a crime, a defendant will be liable for homicide by causing a person to commit suicide only when he purportedly does so by force, duress, or deception. And as your lordships know, a direction consistent with that was given in the case of Anne Moreton, not in the case of Ben Field, although Hart and Honore draw the parallel between the two instances as is correct. So, emphasizing, if I may, the fact that again, the learning provided by Hart and Honore repeats what Lord Bingham said in Kennedy, that 2 things have to be proved. The accused has to cause the second act, and the intervening actor's conduct, in this case Mr Farquhar, is not wholly voluntary. And although the phrases used in that extract that's just been read to the court are coercion, deceit, and the exercise of authority, and also force, duress, or deception, other words are in fact used in the text. It's not so much the language that matters, it's obviously the concept and different languages used to describe that concept in different places. Mr Perry conceded, because he represented the prosecution in Kennedy, Mr Perry conceded, this is at paragraph 13 of the judgment, that he could not hope to show that the defendant in that case had caused the noxious substance to be taken by the victim where it had been freely and voluntarily self-administered by the victim. The principal factual difference, there are others, obviously the victim in Kennedy was an addict who can be presumed to have had a stronger craving for drugs. Mr Farquhar was not addicted to alcohol in any way. But the principal factual difference between the 2 cases was Field's hidden intention. But once it's recognized that the essential inquiry is whether Field caused Farquhar to ingest whisky and or Dalmane rather than gave it to him, and that Farquhar's ignorance of Field's intention cannot have caused him to ingest those substances, then it's plain that in neither case could it be proved that the defendant had caused the ingestion. And therefore, the concession that Mr. Perry made in the case of Kennedy is one that should commend itself to him in the case of Field. Before leaving Hart and Honoré, my Lord, may I go back to those words in a similar way in the extract that I read to the court. In a similar way, the principle they describe applies to causing suicide, so that encouraging suicide could only amount to homicide where the defendant causes the victim to commit suicide by force, duress, or deception. That statement of the law therefore applied equally to the case of Anne Moreton. To be guilty of murder, the first actor, in this case Field, must cause the act of the second actor, and the means used by the first actor, whether they be inducing the second actor to consume whisky and Dalmane, as in the case of Farquhar, or in encouraging suicide, as in the case of Anne Moreton, must amount to force, duress, or deception. The prosecution case fell into the same error when framing its case against Anne Moreton as it did when framing its case against Field. It included, in its case against Anne Moreton, encouragement to suicide as one of the mechanisms by which death was said to have been intended as part of the alternative charges of conspiring to or attempting to murder her. Neither the encouraging of suicide nor the giving of whisky and or Dalmane were acts that could have caused death without the use of force, duress, or deception in order to induce them. This was recognized in the case of Anne Moreton when on Thursday, the 4th of July, 2019, at 11:01 in the morning, as the time for directing the jury approached, Mr. Justice Sweeney handed down his reasoned ruling on whether murder could be committed by encouraging suicide. My Lord, the ruling itself, I don't ask you to turn to it, the ruling itself is at item 2, the relevant paragraph is at para 26, page 13 of the ruling, and indeed a chronology of the court has been provided for the court, which is at item 80, and that is hyperlinked, and it sets out exactly the order of events that occurred at around the time the jury discussions the jury directions were being discussed, and the purpose of that is to show the timing of the service of the handing down of the Anne Moreton judgment and the consequential change made to the prosecution case. The reason handed down by Mr. Justice Sweeney as to whether murder could be committed by encouraging suicide concluded with, however, for the principled reasons that the defence have advanced, they are, in my view, right to concede that in the circumstances identified by Hart and Honoré, a defendant's conduct may amount to murder if he drives the victim to suicide by force, duress, or deception, with the deception being as to the nature of the act encouraged, such that the suicide was not the voluntary act of the victim. And the jury, as I've said, were directed in accordance with that ruling, and the references for that fact, going back to the directions, it's item 9 again, internal pagination 28, DCS pagination 301 in respect of conspiracy to murder, and page 303, DCS pagination 29, internal pagination in respect of attempted murder. The similarity identified by Hart and Honoré between encouraging the act of suicide and encouraging the ingestion of whisky ought to have been recognised in the case of Farquhar and brought to an end that case to the extent that it was based on murder by giving whisky and or Dalmane. it didn't lead to the end of that case, because a little under 2 hours after the handing down of the judgment in the Anne Moore-Martin argument, at 12:56 on the 4th of July 2019, again, all set out in the chronology at item 80, the prosecution served an amended note on the directions of law. That note is note 2, and the reference for that is in that bundle of arguments. That is at item 29 of the DCS, and the particular page where this note is found is 839BQ. And by that amended note, the prosecution advanced for the first time the argument that it does today, the argument that Farquhar's act of ingesting whisky could not have been free, voluntary, and informed because he was uninformed of Field's intentions.
Sorry, which page was that?
It's page, my lord, 839BQ, item 29. I'll confirm that that is correct. Yes, item 29, my lord, is the, it starts with a schedule of submissions, and I think it must have been inserted subsequently because the creator had run out of numbers and resorted to letters. So your lordship needs to go to 839BQ. Yes. If you wish to use the internal pagination of that bundle of submissions, the reference is page 69, if that is easier. That's where directions of law 2 is found. I won't, unless you think it would help, take you through the document, but if you choose to read it and compare it with the prosecution's first document, the one served before the handing down of the judgment in the case of Anne Moore-Martin, you will see the changes that are made in terms of the two documents, and you will see that for the first time, and it had never been mentioned before in opening or at any other stage of the case, for the first time, the claim that Farquhar could not have been acting in a free, voluntary and informed way if he was uninformed of Field's intention was advanced. And that was, I think I described it in the grounds of appeal, perhaps unkindly, as a piece of last-minute improvisation. But that is actually what it was. It was a response to the realization that the judgment in relation to Anne Moore-Martin, in a, as Hart and Honorary call, similar situation, that unless the prosecution came up as it did with the argument that advances today, unless the prosecution came up with the argument that he couldn't have been, Mr Farquhar couldn't have been informed because he didn't know of intention, that's when that argument first emerged. It had not emerged at any time prior to that time. It was a direct reaction to the handing down of the ruling in the Anne Moore-Martin case. And it should have been, in our respectful submission, my respectful submission, it should have been the end of the case on whisky and Dalmane. But because of that argument, first advanced at that point, which Mr Justice Sweeney, under the, and I know this court, this particular court, has many times commented upon the pressures in which first instance judges work, and that certainly was true, as you will see from the chronology of the facts of this case. But regrettably, it was a submission that Mr Justice Sweeney acceded to, with the result that we're here today.
Mr Jeremy, you just then, in the course of that submission, used the words whisky and Dalmane. Well, do the same considerations apply to both of those potentially noxious substances?
Yes, they do. I've used it in a formulaic way,
yes,
rather than to be taken literally. It becomes particularly relevant when we come to ground 3. But
Yes.
your Lordship's right. In fact, the directions, insofar as they dealt with causation at all, only referred to whisky.
Yes, but whereas the case proceeded on the basis that Mr Farquhar drank the whisky volitionally, whether informed and deliberately and freely, but he did drink it and he knew what it was. What's the position about the Dalmane?
What's the position, my Lord, in the sense of?
How did he ingest it?
Well, there is no evidence as to exactly how he ingested it. The only evidence, and I'll come on to this when I come on to answer the third
Yes.
question.
Yes.
But no, I'll answer it now if it helps. The only evidence available in answer to your Lordship's question is that the amount he ingested was consistent with the therapeutic dose, that he was a lifelong user of Dalmane, and that while Field had poisoned him, smuggling drugs into his food, that poisoning, and there are multiple sources of evidence for this, that poisoning had ceased 3 weeks or so before the night on which he died. And that really, I'll check my notes and I'm going to come back to this question when we come to question 3, but I think that's it as far as the evidence in relation to the Dalmane is concerned. There certainly was.
He still had Dalmane in the system.
He had Dalmane in his system, my Lord, absolutely. Yes, sorry, did I not make that clear? But it was consistent with a therapeutic dose. And he was, the evidence showed, a lifelong user of Dalmane.
And Field accepted that he'd been secretly giving that to the deceased.
When you say that, various drugs, my
Yes,
Lord,
yes.
up until
Yeah,
3 weeks
including
before.
Dalmane.
I'm not sure whether it included Dalmane, but accepted multiple benzodiazepines,
Yeah.
of which Dalmane is one, were given up until 3 weeks, 3 weeks before.
Yeah, thank you. It is the third ground, really, but we have to be careful to distinguish the meaning of whisky and Dalmane from the meaning of whisky and or Dalmane.
We do, and if I didn't make it clear, I regret that, but I was using it, as I say, formulaically, rather than trying to be precise.
I understand.
So the third question, my Lord, was there evidence that on the night that Mr Farquhar died, Field caused him to ingest whisky and or Dalmane, and that his ingestion was not fully voluntary? That the answer to this question is no, is acknowledged by the prosecution by the way in which it's put its case in opening. My Lord, I've already referred you to this extract, so I won't repeat it in the introduction, but the opening note for your reference is at item 15, and as I've said, the CCRC obtained a transcript of what was actually said. That is at item 52, which is the CCRC's statement of reasons, and it's at page 86 of 52. I believe that's page 86 of the statement of reasons, in other words, an internal pagination rather than the digital case system pagination. But nowhere in the prosecution's opening was it suggested that Field caused Farquhar to consume whisky and Dalmane by the use of force, duress, or deception on the night that he died, or that Farquhar's ignorance of Field's intentions rendered Farquhar incapable of acting in an informed way, so that Field, rather than Farquhar, was responsible for causing Farquhar's ingestion of those substances. The justifications of the directions that the respondent now gives have all therefore been conceived of after the emergence of the problem that the way in which the case was put created. In the course of an opening note that was 88 pages long, the only reference to what Field was said to have done on the night of the 25th, 26th of October was the one that I've already read in opening. In other words, Farquhar had taken or been given more sedatives that evening. He had drunk or been encouraged to drink a quantity of alcohol, and possibly that might have killed him, or else he had died in some other way, most obviously from smothering from suffocation. The transcript of what was actually said, and I haven't read this to your lordships in introduction, but the transcript of what was actually said adds the concession that Farquhar's ingestion of sedatives might have been voluntary. The reference is item 52, statement of reasons, 171F to H, and digital case system reference 1295F to H. And what was actually said is this: in other words, Peter Farquhar has taken himself voluntarily or been given more sedatives that evening. The sedative in his system was the sedative he was prescribed, although the experts say he had only had occasional exposure to that over the last few months before he died. Had taken or been given more sedatives that evening, and he had drunk or been encouraged to drink a quantity of alcohol, 277 millilitres, and either this mixture had killed him, as if the defendants 1 and 2 had done the giving and encouraging, must have been, we say, their intention. Again, by these words, the prosecution was presumably unwittingly acknowledging that it couldn't prove that Field had caused Farquhar to ingest whisky and or Dalmane, and so could not prove that he had caused Mr Farquhar's death. It accepted, as the evidence compelled it to, that Peter Farquhar might have taken sedatives voluntarily that evening, that he had either drunk or been encouraged to drink a quantity of alcohol, and it simply is not possible as a matter of law to cause the death of another by giving a substance that the other takes voluntarily, the word used in opening, even if that other is encouraged to do so. The quote that I think I've already read, taken from Kennedy, from Professor Glanville Williams, the one I may suggest reasons to you for doing something, etc., demonstrates that. Professor Ormerod, in his commentary on Kennedy, my lord, that's available to you at item 33 at page 224. I think that's an internal pagination. The DCS pagination is 893. Professor Ormerod described Kennedy as providing a most welcome, clear, and concise restoration of orthodoxy to the fundamental principles of causation. But that restoration of orthodoxy had been ignored when the prosecution came to frame its case. That the evidence did not allow the prosecution to suggest that Field had caused Farquhar to consume whisky and Dalmane by force, duress or deception, is also plain not just from what the prosecution said about its own case, which I've taken you to, but from the summary of the evidence provided by the trial judge in his summing up. My lord, that is at item 5, and the relevant pages are pages 51 to 203. My lord, as far as these are concerned, as I've said, I will, unless you wish me to, for every proposition I outline, I won't read out the relevant passage. They're all in the note and they will be available to you. So I will simply focus on the propositions, all of which were reminded to the jury by Mr. Justice Sweeney. The evidence that he reminded them of was that Peter Farquhar was partial to malt whisky. By his own estimation, he drank a little too much of it, and his journals record his desire to moderate his drinking. He was an intermittent but long-term user of Dalmane. There was no evidence that the whisky had been adulterated to increase its strength. It was tested and found to be around 61% proof, the content advertised on the label. The bottle of malt whisky found at his side had originally contained 700 millilitres, of which 145 millilitres remained. The amount of alcohol found in his vitreous fluid was 340 milligrams per decilitre, which would have accounted for 277 millilitres of the missing 555. 77, my lord, of the missing 555. Mr. Justice Sweeney, in the summing up, endorsed the suggestion that the fact that the same amount, 278 millilitres, was missing might be explained, as had been consumed, might be explained by the fact that he and Field had been drinking together that night. The amount of Dalmane found in Mr. Farquhar's system at post-mortem was consistent with his prescribed dose. There was no evidence that he was forced or deceived into consuming either, and no other marks or injury or assault found at the post-mortem. While benzodiazepines and other drugs had been administered by Field covertly in the past, the records kept by both men, and both Field and Farquhar were meticulous record keepers, suggested that the covert drugging had taken place between the 26th of January 15 and the 30th of September 2015. The fact that the covert drugging had stopped over 3 weeks before Farquhar's death on the 24th, 25th of October was corroborated by the numerous witnesses who reported Mr. Farquhar being back to his old self by the time of his death. And it was further corroborated by the expert evidence following the examination of the chemical traces in Mr. Farquhar's hair. As I say, for every one of those propositions, the specific reference is included in the note. In short, there was no evidence capable of disproving that Mr. Farquhar's death that night had been caused by the potentiating effect of his voluntarily taking a therapeutic dose of his prescribed sleeping drug and too much malt whisky to which he was partial. There was no evidence that Mr. Farquhar had been forced or deceived into drinking whisky or taking Dalmane from Field that night. There was no evidence that Farquhar's ingestion had been caused by Field. Mr. Farquhar knew what he was being given. He knew who he was given it by. On the evidence, the act of consuming whisky and or Dalmane that night was Peter Farquhar's act. So the evidential difficulty faced by the prosecution was not, as is suggested at paragraph 13 of the Respondent's notice, that's found at item 68 of the digital case system. The difficulty faced by the prosecution was not, as claimed by the Respondent today, that in common with a missing body case, it could not be proved how Field had caused Farquhar's death. The difficulty was in proving that Field had caused Farquhar's death. It was more than a difficulty. The prosecution could not prove that Field had caused Farquhar to ingest the whisky and or Dalmane, and so prove that he had caused his death, which is why they turned back to the act of giving. As far as ground 2 is concerned, my lord, excuse me for a moment. As I think I said at the outset, in fact, if I did, I won't repeat it. I'll move on. Under ground two, it will be submitted that the Respondent's argument that Farquhar's act of ingestion could not have been free, voluntary, and informed as a matter of law because it was not informed as to Field's intention, and so did not have to be left to the jury to determine. It is not only wrong, but the opposite is true. It will be submitted that for the reasons given in the authorities on the effect of deceit on consent in the context of sexual offending, Field's deception of Farquhar was not capable of rendering his ingestion less than free, voluntary, and informed. The submissions under ground 2 will be considered under the following headings. First, the reasons why the central argument made today in the Respondent's notice misses the mark. Secondly, the implications of the respondent's argument. Thirdly, the assistance provided by the legal authorities concerning consent procured by deception in sexual offending cases. And fourthly, the history of this case, specifically the differing reasoning by which the jury directions have been upheld to date. And the reason, my Lord, for the inclusion of that fourth heading is that differing reasons for justifying the jury directions in this case have been given by trial judge, the respondent, and this court twice, in fact. One reason in its draft judgment, and a second and different reason in its final judgment. And the appellant relies on this history of confusion and contradiction because it shows how difficult it is to justify what really is unjustifiable, and that is the directions given to the jury in this case. So the first heading is the reasons why the central argument made in the respondent's notice misses the mark. The respondent's notice at paragraph 40 states that the central questions in this appeal are first, whether the jury directions were correct, agreed, and secondly, and I'm going to quote from the second central question, whether if Peter Farquhar knew exactly what the substance was that he was drinking, but was ignorant of the appellant's cynical motives and his intention that Mr Farquhar should die, he was in law sufficiently informed to break the chain of causation. That, the respondent says, is the second of the two central questions in this appeal. It's not. It would only be the central question in this appeal if the premise of the question, that by giving whisky and/or Dalmane to Farquhar, Field could have caused his death by starting a chain of causation going, if that premise is correct. But that premise is not correct. The act that caused Farquhar's death was his act of ingestion, and the act of giving, on the evidence when the law is applied to it, on the evidence in this case, could not have caused the act of ingestion. A chain of causation, which the respondent claims exists in this case, and which is the foundation for the central argument it makes, a chain of causation must have a minimum of two links to be a chain, and each link or act must cause the next one in a way that throwing a glass of acid into the victim's face, in the case of Wallace, started a chain of causation going that led to the victim's death. So the first question must be, did Field's act of giving cause Farquhar's act of ingestion, and so set a chain of causation in place? Only if the answer to that question is yes, would the question of whether Farquhar's ignorance as to Field's intention break that chain of causation. In this case, Field's act of giving could not have caused Farquhar's act of ingestion. It could only have done so if Field had forced or tricked Farquhar into the act of ingestion. There was, therefore, no first causative link and no chain of causation to break. So the central argument made in the respondent's notice, in relying on the act of giving to start a chain of causation, makes the same mistake that the prosecution did when framing its case. It fails to identify correctly the act that caused death. And having taken that act to be the act of giving whisky and/or Dalmane, the argument then assumes, with no evidential basis, that the giving caused the ingestion and so started a chain of causation going. The respondent's argument thus bypasses the requirement that the defendant's act must cause the victim's act before the defendant can be said to have caused the consequences of the victim's act in exactly the same way that the prosecution did when framing its case. The next of the headings is the...
In a sense, of course, there was a chain of causation.
I'm so sorry.
In a sense, of course, there was a chain of causation from the giving to...
My Lord, I'm so sorry. I'm sure it's my fault. I'm finding it very hard to hear your...
In a sense, there was obviously a chain of causation from the giving to the ingestion. But for the giving, there wouldn't have been the ingestion.
But for causation, my Lord. Exactly so.
There is a chain there. But you say that that's just not a relevant chain because of Kennedy.
Because this is legal causation, or it should be legal causation, not but-for causation. There's obviously a distinction between the two. So your Lordship's right that it's a chain, but it's not a causal chain. The giving is not...
Well, it is a causal chain. You say it's not a relevant causal chain, and that is clear from Kennedy.
Yes.
Maybe factually causative, but not legally so.
The difference between but-for causation and imputable causation. Exactly. The second topic, and in a sense, my Lord, thank you for repeating it now that I've understood your point. Of course, but for the giving, there might not have been consumption, but for Field not being present in the house, none of this would have happened. The but-for chain is never ending, but we are dealing with imputable causation. The implications of the respondent's argument. As already stated, reduced to its essence, the respondent's argument amounts to the proposition that ignorance of the defendant's intention renders a victim incapable, as a matter of law, of acting autonomously. That is the essence of the argument that's put forward. So that anything that the victim does at the prompting of the defendant would have been caused by the other. Free, voluntary, and informed are words used to define the concept of autonomy, amongst other words. What matters is the underlying concept and the purpose of the use of the language, and that purpose is to distinguish acts that, in this case, are the acts of Mr Farquhar from the acts of Field. Uninformed. We are all uninformed. That doesn't prevent us from making informed choices. The important question is not whether we are uninformed, it is whether we are informed about what we need to know in order to make the act that we perform our own act. The respondent's argument, conceived, as I say, at the end of this case, the trial that is, the respondent's argument has latched onto the word informed, taken it out of context, and applied a literal meaning to it, which ignores the purpose behind its use. In asking whether Mr Farquhar was informed as to Field's intentions, the respondent asks a different question to the question as to whether Farquhar's act of ingesting whisky and or Dalmane was free, voluntary, and informed, and thus his own act. If the respondent's submission in this regard is correct, it would follow that Farquhar could not, as a matter of law, have been acting in a free, voluntary, and informed way, so long as he remained unaware of Field's intention. He would have been incapable of acting autonomously, incapable of giving Field permission to remain in his home, incapable of consenting to being touched by Field, incapable of either lending or giving him property. Every act of Field would have been a trespass, an assault, a theft. It would also follow that Farquhar would only have been incapable of acting autonomously in relation to his dealings with Field, because it was his ignorance of Field's intention that rendered him incapable of acting in a free, voluntary, and informed way, suggests the respondent. He would be capable of exercising free will in every other respect. So it would follow that if a third party, X, had been drinking together with the two of them that night, taking turns, each of them, to fill the glasses, then Mr Farquhar would have been moving in and out of the state of autonomy, depending on who filled his glass, capable of acting autonomously when drinking from a glass filled by X, but not if filled by Field. The argument would also have wider application than to relations between Mr Farquhar and Field. It would apply to any other situation in which one party is ignorant of the intentions of another. So a wife, unaware of her husband's secret intention to leave her for his mistress, and so incapable of exercising her sexual autonomy, would have been raped if she had what would otherwise be consensual sexual intercourse with him while ignorant of that intention. This, as the authorities on the effect of deceit on sexual autonomy show, is just not the law. So merely by considering the implications of the respondent's submission, it can be seen that it is a submission that does not really bear consideration. The third heading under ground 2, my lords, is the assistance provided by the legal authorities concerning consent procured by deception in sexual offending cases. Well, that heading for this section is taken verbatim from paragraph 22 of the judgment of this court, presided over by the then head of the Queen's Bench Division, when it refused the appellant's application to reopen this appeal under Criminal Procedure Rule 3615 on the 16th of March 22. Lord, you have that authority. It's at item 81 of the DCS, page 1993. And at paragraph 22, Dame Victoria Sharp said, "We record that no reliance was sought to be placed by either party on legal authorities concerning consent procured by deception in sexual offending cases." The judgments of this court do not include many redundant words, and that is certainly true of the judgments of the then President of the Queen's Bench Division. Although these authorities were concerned with consent procured by deception in a different context, the context of sexual offending, consent is an expression of sexual autonomy. The definition of consent provided by section 74 of the 2003 Sexual Offences Act is, for the purposes of this part, a person consents if he agrees by choice and has the freedom and capacity to make that choice, which chimes with the description of Lord Bingham at paragraph 14 of the judgment in Kennedy. The criminal law, starting with the criminal law, assumes the existence of free will. So consent to sexual contact is an expression of autonomy in a sexual context, and these authorities are relevant to the issues that arise in this case. Consideration of these authorities explains how the respondent's argument makes the error of focusing on what was described in the case of, Lord, I've been rehearsing this, but I am going to get it wrong, Papadimotropoulos, as the antecedent-inducing cause. In that case, the existence of a valid marriage; in Field, the existence of a loving relationship, rather than the essential inquiry of whether Farquhar's act of accepting drink from Field was free, voluntary, and informed. Now, as far as these authorities and their relevance to this case, and in particular to the argument that the respondent advances, and whether the respondent is right that the act could not have been, Farquhar's act could not have been voluntary as a matter of law, and the appellant's counter-argument that as a matter of law the deception couldn't have rendered it involuntary, I'm very much in the court's hands, because these arguments have been set out in the grounds of application to the CCRC, which is annexed to the Statement of Reasons. The reference to that is item 52. That's the Statement of Reasons. It's page 38, in particular at pages 45 to 56, or DCS references 1162 at 1169 to 80. And it's repeated in condensed form in the executive summary provided by the CCRC, which, as the title suggests, is a condensed version. My Lord, I don't intend to repeat those submissions. They're all in writing, they're available to you, and from what you've said, you've read them. I don't believe I would help by repeating what I've already written. You will tell me if I'm wrong.
No, I don't think so. No, thank you.
Can I then go back on one part of what I've just said, which is to commend to you in particular two of the passages in the grounds of application. And the first is the decision in Lineker. The judgment in Lineker is also available at item 70. And it's referencing to the Australian case of Papadoumitropoulos. That's also available at item 69 on the DCS. Can I refer you particularly to paragraphs 37 to 39 of the grounds of application, where the helpful extract is quoted in Lineker, and I add, as it were, the argument around it. And the second passage that I would particularly invite your attention to is the section titled in the grounds of application, the application of the law decided by these authorities to the facts of field. And that is at paragraph 54 to 61. These passages demonstrate that the error made in the judgment in field was to focus extensively on the defendant's deceit rather than the question of whether Farquhar's act of ingesting had been free, voluntary, and informed. To be free, voluntary, and informed, what was required was an understanding of what Farquhar was ingesting and who had given it to him. The deception as to Field's feelings and intentions was not relevant to the voluntariness of Farquhar's act of taking whisky and or Dalmane from Field. An attempt to demonstrate this by applying the rationale of Lawrence, as quoted at paragraph 52 of the grounds of application to the facts of Field, is made at paragraph 58 of the grounds of application. And in fact, may I actually read that to you?
58.
Because it resonates, we suggest, very, very powerfully with the facts of this case. And the purpose of that exercise at paragraph 58. Well, I'll read paragraph 58 in the extract, if I may. That both Lawrence and Field ought to have been decided in the same way can be demonstrated by an examination of how readily the language of paragraphs 34 to 38 in the judgment in Lawrence, quoted at paragraph 52 above, could have been adapted to make it applicable to the case of Field. Had the court in Field applied the principles applied in Lawrence, it might have said, Field's deceit of Peter Farquhar, that he loved him rather than that he wished him to die, was central to Farquhar's choice to share his house and his life with him. It is inconceivable that Mr Farquhar would have taken drink or anything else from Field had he been aware of the deceit. However, the but-for test is insufficient of itself to vitiate consent. There may be many circumstances in which a victim is deceived about a matter which is central to his choice to do an act, but the fact that the victim has been deceived and would not have made that choice but for that deceit does not necessarily render that choice involuntary. The question is whether a lie as to Farquhar's true feelings and intentions, I'm sorry, that must be Field, a lie as to, yes, Field's true feelings and intentions is so closely connected to the nature or purpose of taking whisky from Field, rather than the broad circumstances surrounding it, so that it is capable of negativing the voluntariness of Farquhar's choice to take it. Is it closely connected to the taking of whisky? In our opinion, a lie about feelings and intentions is different from lies told about whether a condom would be worn during sex, about an intention to withdraw having promised to do so, and about the gender of the defendant. Unlike the complainants in those cases, Farquhar agreed to take whisky from Field without imposing conditions. He agreed to take and drink whisky. The evidence showed that Farquhar enjoyed malt whisky and drank it regularly. In taking whisky from Field, he received exactly what he'd agreed to take. He was neither tricked nor forced into drinking it. When he did so, he had been deceived about Field's feelings and intentions towards him, and therefore about the risks and possible consequences of drinking to excess in his company. The deception was one which related not to the physical of taking of whisky, but to the risks or consequences associated with it. Farquhar was not deprived by Field's lies of freedom to choose whether to drink whisky or not. And my lord, if you do choose to read back to the judgment in Lawrence, then you will see, I hope, how that attempt to apply the facts of Field to the rationale of Lawrence illustrates what is really an indistinguishable situation on the facts between the two, except, of course, that in Lawrence, the contrary finding was made, not as a matter of law capable of undermining consent. The next topic, my lord, is the history of this case, specifically the differing reasoning by which the jury directions have been upheld to date. And that I'm going to break down into 4 topics. The first topic, the errors made in directing the jury. Second topic, the rationale for the directions as understood by trial judge and as revealed in the response to the jury questions. Third topic, the reasoning of this court when dismissing this appeal in both its draft and final judgments. First topic, the errors made in directing the jury. I've already taken your lordships to the directions. Perhaps the simplest way of demonstrating how we would respectfully suggest the jury should have been directed in this case is to invite the court's attention to the 2, admittedly imperfect, routes to verdict that were provided on behalf of the appellant. One was actually provided at the time of the discussion of the jury directions before, in fact, anything had been provided in writing by the court. It was provided on behalf of the appellant at that stage. Your lordship knows what I'm referring to. It was provided at that stage because following the indication of a favourable, as far as the appellant's concerned, favourable ruling in relation to the argument around Anne Moreton and whether suicide could be merely encouraged in order to amount to murder. Following that ruling, the appellant submitted that route to verdict really in order to demonstrate the fact that the prosecution could not prove a case if an appropriate direction was, following on consistently with the ruling given in Anne Moreton's case, the prosecution could not prove its case if a correct direction had been given to the jury. And that was the purpose of providing that at that stage. If I can give you the reference to it, it's again at item 29, that bundle of submissions, and the internal page is page 57, the internal page of that bundle. CACD, it's not CACD, digital case. The digital DCS, digital case system, reference is page 839BE. And that draft route to verdict was provided based on what turned out to be a misplaced confidence that the consequence of the Anne Moreton ruling would lead to the end of the case on whisky and or Dalmane. And what that RTV, imperfect as I absolutely accept, what it did at step 7 was to borrow from Hart and Honoré the requirement that the jury be sure that Mr Farquhar had been forced or deceived into consuming the alcohol given to him by Field to the extent that he'd been deprived of his capacity to exercise free will and could not be regarded as acting voluntarily. A pared-down version of that route to verdict, perhaps improved but probably only slightly, was attached to the appellant's argument of the 14th of December of 20, the argument prepared for the hearing before this court at the hearing of the first appeal, and that is available at item 45, internal page 40, digital case system reference, page 1082. And that route to verdict at step 3 required the jury to be sure that Farquhar had been forced or deceived by Field into consuming alcohol, and the supplementary directions drafted to go with it explained that the force or deceit must have deprived Mr Farquhar of his choice. Now, the reasons, I won't take your lordships to those routes to verdict unless you feel it would help.
No, thank you.
The reasons given for rejecting, only the first one had been served at the time of the trial, at the time of the giving of the legal directions, and the reason for rejecting those proposed directions was not given by Mr Justice Sweeney until his ruling on the 30th of August of 2019. The trial had ended in early August. And his reasons for rejecting them are at item 6 of the digital case system. And those reasons are confined to 3 short paragraphs at paragraph 4 of the document. And I will quote those to the court. Yes, as I say, it's item number 6, heading Jury Directions on Murder. This is the reason for rejecting the RTV. My direction, paragraph 3, my directions on murder and the ultimate questions for the jury to consider are set out. Against the background of the issues raised in the, quotes, route to verdict and the note on draft legal directions on behalf of Ben Field, 1, I declined to follow the proposed directions on count 1 because in my view they were unnecessarily complicated and not in accordance with the context-specific law on causation identified in the combination of the cases to which I was referred, including Kennedy, Hughes, B. W., all cited in detail in Reasons Encouraging Suicide Murder. I concluded that as ultimately drafted, my summing up legal directions in the combination of the directions and the ultimate questions were both in accordance with the law and simpler for the jury to follow. I saw no conflict between that approach and my ruling as to the limited context in which encouraging suicide can amount to murder, which involved, as to causation, a necessarily cautious approach to an extension of the common law in an area the subject of a statutory offence. I took the view that the ultimate version of my directions to the jury avoided any possibility of the jury convicting on the basis of Ben Field not being present, but leaving the bottle for temptation, see pages, etc., but rather ensured that he could only be convicted if the jury was sure that the prosecution had proved its case as opened. My Lord, given the divergence between the directions, the fundamental divergence in the directions proposed in the route to verdict, along with the accompanying directions, and what the jury directions actually contained, those reasons, and those were the only ones given for rejecting the route to verdict, were, with the greatest respect to Mr Justice Sweeney, not adequate. If I could pick up on the last words, I took the view, ... that my directions ensured that he could only be convicted if the jury was sure that the prosecution had proved its case as opened. The learned judge's faith in ensuring that Field could only be convicted if the jury was sure that the prosecution had proved its case as opened was misplaced. The prosecution did not have a case as opened. What was opened was a case in which Field might have been merely, Farquhar might have been merely given, persuaded to ingest, or even ingested voluntarily the substances that caused his death. That was not a case on causation. What was open was a case that could not prove that Field had caused Farquhar's death. And his lordship was still labouring under the misapprehension that the murderous act was the giving rather than the causing the ingestion when he gave the ruling, and he was right to say this, that the directions, as it were, ensured the jury applied the prosecution case or had proved the prosecution case as opened, but without addressing the fact that the case as opened was not a case. The next topic, the rationale for the directions as understood by trial judge and as revealed in the response to the jury directions. I've already drawn to your attention some of the exchanges between junior prosecution counsel and trial judge at the time of the jury questions. I am going to invite the court to consider the entire transcript of that section because it is revealing. And in short, and I'll come on to it in long if necessary and if your lordship would be assisted by it, but in short, Mr. Justice Sweeney was entirely correct when he said, as he does in the exchange with Mr. Rokes, not in the passage I've read to you, but when you look at the full transcript, when he said that causation was a matter of fact for the jury to decide. The problem was that he was looking at causation through the lens of the act that caused death being the giving rather than the ingestion. So he thought that causation couldn't be an issue. When he addressed the jury in response to its note, the note is available, your lordship is familiar with the terms of the note.
Yes.
When he addressed the jury in response to that note, he was fixed with the written directions which had identified the giving of whisky as the causative act and which had therefore not left causation of the ingestion of the whisky to the jury to decide. He started by repeating what he had already said in the written directions, but putting it in a different order. He then went on to give what he would refer to as a few words of extra explanation. Those words told the jury that it would not be right to convict Field if Farquhar had drunk in the knowledge of Field's intention. But the obvious corollary of that was that it would be right to convict Field if Farquhar had drunk in ignorance of that intention. And that is why it is submitted that the jury was effectively invited to find that Field had caused Farquhar's death. Mr. Justice Sweeney would only have been able to put his understanding that causation was a matter for the jury into effect if he had torn up the written directions that they'd had for several days by then and started again with the correct causative act. Now, my Lord, what I've just said to you can be said at greater length, taking you through the transcript of those exchanges. And again, I'm entirely in your hands. Before I make an offer that I then slightly retract, can I draw your attention to one part? I'll read the whole extract, part of which has been read already, that exchange following the jury note. You will find it at item 5, and the reference, the DCS reference is page 171H. And the pages subsequent to that include the exchanges that I've summarized. the passage I've already read to you, where both Mr. Rokes and Mr. Justice Sweeney agree that the giving was a cause of death, it simply must have been, and Mr. Justice Sweeney then says, but it remains a matter of fact for them. Rokes goes on to say, I just, in the light of the question being asked specifically about that paragraph, I just wonder whether or not they're getting bogged down on that issue. The questions they really need to determine are intention at the time the drink was passed over, and Farquhar's state of knowledge at the time that he consumed that drink. In relation to the latter, I don't think it's been sensibly suggested by anybody at any stage that he took a drink knowing that Mr. Field was intending to kill him. I accept, of course, my Lord's point, but whether or not that's a realistic conclusion on the evidence in this case may be something that my Lord feels able to comment on. The junior prosecution was right in everything that he said in that extract. The only question on these directions that the jury needed to determine, according to the directions, was as to mens rea and as to whether Farquhar took drink knowing that Field intended to kill him. He was also correct when he said it hadn't been suggested that Farquhar would have done this. It hadn't been suggested on behalf of Field. It would have been very unrealistic to do so. And he was also correct when he said that this would not have been a realistic conclusion to reach. And what he was doing there in those exchanges was expressing, perhaps without realizing it, the consequences of the directions that the framing of the prosecution case had led to. Conviction on the basis of the perpetrator's mens rea and the victim's ignorance of his mens rea alone. But while both prosecuting counsel and Mr. Justice Sweeney acknowledged that causation was a matter of fact for the jury to decide, the difficulty was that the directions hadn't left that question to the jury, and the attempt to correct it could not succeed without starting again. So these directions, and again, I think I started to ask the question but didn't give your lordship the chance to answer it, but I can take you to the passages or not.
No, we have read this transcript and we are aware how the directions came to come into existence. Obviously, the principal question is whether in the final version they were whether in the final version they were adequate.
Yes. Well, if that's that is the final question. If there's doubt about that, then can I take you to the directions themselves?
Yes, if you wish to.
To the transcript, I should have said. I think I said it was number 5.
Yes.
And ECS page 71.
This is a transcript of the summing up.
Transcript of the summing up, my lord. Item number 5.
I now have it as a separate document, so it's helpful for me if you give the page numbering on
page
the
number
transcript.
On the transcript is, I think it's about 70. Signing myself. I seem to have given myself the wrong reference. I'm so sorry, it's page 175 if I said 75. I'll give you the correct internal numbering. Internal numbering in the area of 125, my lord.
Thank you.
Digital case numbering 175.
Yes.
The jury enter court, 1/3 of the way down the page, the jury enter court at 11:42.
Yes.
And Mr. Justice Sweeney starts to address the jury. And what he does, which can be seen if one compares this transcript alongside the directions, and indeed as he said he would do, is that he essentially gives the written directions all over again, but in a different order. And he ends that process over the page at page 176D. And he then, having repeated the written directions, goes back to add what he later describes as a few extra words of explanation. So if we then go back to the paragraph about which your question has been asked, if it is proved that with intent to kill, Field gave Farquhar drink, then even if he agreed to drink it, it would be open to you to conclude that the question was the cause of death, unless Peter Farquhar's decision to drink was informed. Why the difference between the two? This is where he starts to say further things to what was in the written directions. In the first part of the sentence, if it is proved that with intent to kill, Field in person gave Farquhar drink, then even if Farquhar agreed to drink it, it would be open to conclude that the giving was the cause of death, unless Farquhar's decision to drink was uninformed and that he knew the drink that was being offered was intended to cause his death. The difference is because it is not the prosecution. The prosecution do not put its case in that way, and they must prove their case. And the reason why they don't put their case in that way is that if Peter Farquhar's decision to drink was in the knowledge that the drink was being offered to him with the intention of causing his death, then his decision in that knowledge to drink would not in law be the only cause of his death. It would not be the responsibility of Ben Field. On the other hand, and here we have the prosecution case, that they were together and that Peter Farquhar most certainly did not know that he was being offered drink with the intention of killing him by his consumption of it, that in those circumstances, even if he agreed to drink, not knowing that it was intended by Field that it was to kill him, it would be open to you to conclude that the giving was a cause of death. And it is open to you so to conclude because then it's a matter of fact. And you alone are the judges of fact. And therefore it would be open to you to conclude, if you thought it right, that in those circumstances, that notwithstanding the agreement to drink, that the giving of the drink or the drug was more than a minimal cause of death. So the words, it's a matter of fact, and you alone are the judges of fact, are inserted following the jury question and the exchange in court in the absence of the jury with junior prosecution counsel and the acceptance that it's a matter of fact for the jury. The words were inserted, but they made absolutely no difference to the meaning of the direction. The direction still left it to the jury being encouraged to find that the giving of the drink was a cause of death. And when he goes on at letter B to say, can I try and put it another way to make it simpler? If at the end of the day it was or might have been that even though they were together, even though Field was intending to kill Farquhar, that Farquhar drank in the knowledge that Field was giving him drink, he, Ben Field, intended to kill Farquhar, then it would not be right to convict Ben Field. If it was or might have been that, then the prosecution would have failed to prove their case, which was that he was given alcohol with the intention, and most certainly without the knowledge that Ben Field was intending to kill him. Is that clear? I see nods. So that is what I was referring to, my Lord, when I said that a proposition was put to the jury, the explanation that it wouldn't be right to convict if Mr Farquhar knew of Field's intention. The obvious corollary of that was that it would be right to convict him so long as he didn't know of Field's intention, which was what the original directions had already done. So the additional words added to the original directions added nothing of any meaning or significance to the written directions as already given, except for the inclusion of the words, you have to be judges as matter of fact. But the sense of the directions remained totally intact. These directions, both the original written ones and what Mr. Justice Sweeney described as a few extra words of explanation, were underpinned by two fundamental misunderstandings. One, that it was possible for Field to have caused Farquhar's death by merely giving him whisky and Dalmane, and secondly, that Field's intention was relevant to causation, so that if Farquhar was ignorant of that intention, then Field would have caused his death. Now, the third topic is the reasoning of this court when dismissing this appeal in both its draft and final judgments. My Lord, it would help me to know at what point your encouragement to progress becomes a little stronger.
Yes. Well, I think that point must be arriving. I haven't asked Mr. Perry how long he needs, but we normally work on the basis that people are entitled to a similar amount of time as each other, so we are heading towards a critical point, I would say.
Would it be... Sorry.
You can take it that we are thoroughly familiar with the events which occurred in the 2 previous visits to the Court of Appeal Criminal Division, not because any of us had anything to do with either of them, but because we have read the judgments and what has been written about them with some care.
Would it be acceptable, would the court allow me until the short adjournment, and may that be the guillotine?
Mr. Perry, will that allow you time?
My Lord, yes, I think so. Doing the best I can, I think I'll probably be about an hour and a half.
Fine, thank you.
Doing the best I can.
Yes, well, we're not putting a guillotine on you,
Thank you very
Perry,
much.
as we haven't with Mr. Jeremy. But yes, so it will be highly desirable if you can finish by 1 o'clock, Mr. Jeremy. As I say, you can proceed on the basis that we're pretty familiar with the factual material of what's happened in this court before.
And I know that if I fail to take that into account, you will reinforce it.
And we will want you to deal, while we're on the subject of the previous decisions, on their status as far as we're concerned. As far as we understand the position, we are bound by previous decisions of this court unless they are per incuriam or in ignorance of some argument. And the fact that the CCRC has referred the case back for further consideration does not of itself change the law in relation to precedent. So we will want some assistance on our options.
Is your Lordship suggesting that your options are limited to being bound by the decision of this court when it rejected the appeal?
Only that we'd like some assistance on what you say about that proposition. I'm not saying I accept it, but it's something we will have to deal with.
Well, first of all, it is, as you've raised it, my Lord, can I deal with it now, that the decision of this court when it rejected this appeal was clearly wrong, as we sought to argue on the reopening of this appeal. And if this court feels bound by the finding of that previous court, even if there is material to suggest that it's clearly wrong, then it would totally negate the purpose of a reference that has been made by the CCRC, which is based not only on the further argument relating to the effect of deceit on sexual consent, but the exceptional circumstances provision, which was the second ground on which the CCRC allowed the reference. And as they make plain in their reasoning, that allowed, as they understood it, the reopening of the argument on causation. And if I, having reopened the argument on causation, and the respondent, rightly, we would respectfully say, has not tried to seek that can't be done, indeed it's accepted it. If I am entitled to reopen that argument, but this court is bound by the previous decision of this court, it renders the entire reference procedure utterly pointless.
Well, not necessarily. I do take that point. I do fully understand why you make that submission, but not necessarily, because the court previously refused to certify a point for the Supreme Court. If we concluded that we were bound by that previous decision, we could certify a point and give leave. So it wouldn't necessarily render it pointless. But
yes. Well, my Lord, I hope that won't be necessary, but I understand.
Yes. Thank you.
But on what basis do you say we are not bound? Is this an exception to the rules of precedent and stare decisis in relation to the decisions of the Court of Appeal, which exist because of a reference by the CCRC?
Well, my Lord, if picking up on the observations of Lord Justice Edis, if this court is bound, it would, as I've already said, negate the reference process, and it would mean that, in effect, the only remedy available to the appellant in a situation where, as we, with respect, suggest, the decision of this court in March 21 is clearly wrong. It would, in effect, confine this to a referral to the Supreme Court for the Supreme Court to decide the point. The Supreme Court shouldn't need to decide a point like this, where this court has got something plainly wrong and where the CCRC has invited this court to reconsider its findings. The reasoning of this court, my lords, when dismissing this appeal in both its draft and final judgments, as I've said, two different lines of reasoning were given for upholding the directions. The first in the draft judgment being that the directions did not need to leave the question of whether Mr Farquhar's act of ingestion had been free, voluntary and informed, because it could not have been informed. The second reason, given in its final judgment, was that the directions had left this question to the jury. So first, the justification given in the draft judgment. My Lord, given the timings, I'm going to confine myself, I think, to references. The draft judgment is at item 58 of the DCS. The final judgment is at item 62. And your lordships have a schedule of changes made at item 63. Paragraph 63 of the draft judgment reads, "These directions rightly recognise that in this particular case, if the jury was sure that the appellant was giving Farquhar drink with intent to kill him, of which intention Farquhar was ignorant, then PF's act of drinking could not, my emphasis, could not be a free, voluntary and informed judgment." Following the receipt of the draft judgment, the appellant applied for a rehearing, that is at item 60. I pause in case your lordship wishes me to take you to any of these documents, but otherwise we'll continue. And at paragraphs 8 and 9 of the application for a rehearing, those words that I've just read were reproduced, underlined, and it was pointed out that this was a finding of law. At paragraph 31 of the application for a rehearing, the draft judgment was described as a judgment of law that purports to be a judgment on the facts. The application for a rehearing was refused by email from the Vice President's clerk, dated the 16th of March of 21. The email is at item 61. At paragraph 3 of the email, it is said, they, meaning the appellant, make a separate criticism to the effect that the court has mischaracterized as matters of law certain matters of fact which should properly be left to the jury. That email misrepresents the appellant's complaint, which was to the opposite effect. The application for a rehearing had not complained about the original wording of paragraph 63. On the contrary, it relied on it to demonstrate that the court had circumvented the law, as several commentators have subsequently suggested, by creating a judgment that purported to be a judgment on the facts, based on a factual comparison with the example of the weak swimmer, but it was in reality a judgment of the law. Paragraph 63 of the final judgment, item 62, removed the finding of law that Mr Farquhar's act of drinking could not have been free, voluntary and informed, and replaced it with the assertion that these directions rightly recognised that in this particular case, the jury had to be sure that Farquhar's act of drinking was not free, voluntary and informed. This isn't a clarification of the court's conclusions, it was a fundamental change in the reasoning by which this court upheld the directions and dismissed this appeal. The assertion in the draft judgment that as a matter of law, Farquhar could not have been acting in a free, voluntary and informed way, so that this question didn't have to be left to the jury, was abandoned in favour of the assertion that this question had been left to the jury. In fact, the directions hadn't left this question to the jury. They couldn't be reasonably interpreted as having done so, and the respondent does not claim that they did. It seeks to justify them by different reasoning. But by removing what could have been seen as a finding of law from the judgment that the respondent had invited it to make, this court restored its judgment to an apparent judgment on the facts and in due course refused an application for leave to appeal to the Supreme Court. Before leaving the reasoning of this court when dismissing this appeal, I'd like to consider the respondent's claim made at paragraphs 32, 34, 58 and 62 of the respondent's notice, item 68, that its argument was the one adopted by this court when dismissing this appeal in March 21. That is simply incorrect. The respondent's central argument has already been considered. It was not that these directions had left the question of freedom, voluntariness, and information to the jury. The respondent's attempt in its argument to align its reasoning with that of the court is misplaced. This court didn't adopt the respondent's central argument that Farquhar's act of ingesting whisky and Dalmane couldn't have been free and informed, and the respondent has not adopted the claim made in paragraph 63 that the directions did require the jury to be sure that it had not been voluntary. Each of this court and the respondent was right to reject the position of the other, but the difference in reasoning by which this court reached its conclusions and the respondent seeks to persuade this court to reach a similar conclusion, that difference ought to be acknowledged and explained. My Lords, that concludes, unless you have any further matters, grounds 1 and 2. Can I as I'll have to proceed at pace through grounds 3 and 4.
Yes.
Grounds 3. To the extent that the directions left any question referable to causation to the jury to decide, the question of whether Farquhar had been informed of Field's intentions, this question was left in relation to drink, but not in relation to Dalmane. I've already referred to the relevant extracts from the prosecution's opening and the transcript of what it said as to how it put its case. That there were two mechanisms, which was what had been said in opening, that there were two mechanisms of causing death was confirmed in the discussion on the law on the 28th of June of 19. The Lordships have that at item 19 of the DCS at page 47.8a to c, and also at 48.1d. What's said there in the discussion about the law is, secondly, insofar as Ben Field is concerned on count 1, the jury must consider guilt, whether guilt is proved on the basis opened, and I would add pursued in cross-examination, namely that he either gave him drink and a drug, or in addition finished him off by smothering him. In my provisional view, the prosecution don't have to make the jury sure of which of the two methods that they rely on was the one used. They only need to make them sure that it was one or the other. But in the jury directions, this was expanded to 3. Your Lordships have seen the jury directions, the use of and or. The respondent's notice at paragraph 13 disputes that 2 had been expanded into 3. It says at paragraph 13, the case was left to the jury on the basis of 2 possible routes to death, i.e. 1, drink and or Dalmane, and or 2, smothering. Drink and or Dalmane and or smothering makes 3, even if you call it 2. The particular consequences that follow from turning 2 into 3 was this. Firstly, they permitted the jury to convict Field of the murder of Farquhar by giving him Dalmane alone. The amount of Dalmane found in Mr Farquhar's system at post-mortem was consistent with the prescribed dose. It follows that the directions permitted the jury to convict Field of causing Mr Farquhar's death if he had done no more than, at Mr Farquhar's request, handed him his prescribed dose of Dalmane. And it's not possible to cause death and so commit murder by this act. Secondly, the direction that it would be open to the jury to conclude that the giving would be a cause of death unless Farquhar's decision was informed as to Field's intention referred only to the giving of drink. There was no equivalent direction relating to Dalmane. Legal directions at item 9, page 295. The directions therefore distinguished between whisky and Dalmane in permitting the jury to convict of murder by giving drink only if Farquhar had not known of Field's intentions, but permitting it to convict of murder by giving Dalmane even if Farquhar had known of Field's intentions. Ground 4. The directions did not provide the jury with an adequate direction on minimal cause in relation to the giving of drink and or Dalmane. One or two mechanisms of causing death had been expanded to 3, and once that had happened, the jury would have had to have been given a minimum cause direction in relation to each of whisky and Dalmane. As to the evidence relating to the giving of drink, it was the prosecution case, and the jury must have found that Farquhar and Field had been drinking together that night, as the judge reminded the jury of in his summing up. The quantity of alcohol found in Mr Farquhar post-mortem was consistent with his consumption of about half the volume missing from the bottle. There was no evidence as to how much of the whisky had been given to Farquhar by Field, as opposed to how much he had been poured by Mr Farquhar for himself. And that was almost exactly the question that the jury did ask. Can we have clarity on the 4th paragraph on page 22, especially regarding the implications if Ben and Peter were drinking together? As to the direction relating to the giving of drink, the minimal cause direction ought to have distinguished between drink given by Field to Farquhar and drink poured for himself by Farquhar. Only if it was sure that the former, relative to the latter, could have been more than a minimal cause of death, could murder by giving whisky alone have been a cause of death. There was no such direction. As to the evidence relating to the giving of Dalmane, while there was evidence that the combination of alcohol and Dalmane would have had a potentiating effect, there was no evidence as to how much a therapeutic dose of Dalmane would have contributed to the potentiation. And the evidence of Dr. Bailey, the pathologist who conducted the first post-mortem, was that the quantity of alcohol ingested was of itself just sufficient to have caused death. There was therefore no evidence that Dalmane had been more than a minimal cause of death. As to the direction relating to the giving of Dalmane, it had been omitted entirely from the causation direction. The only reference to it was in question 2 of the ultimate directions. The direction that the jury would have to be sure that Field had given Farquhar Dalmane, which was more than a minimal cause of his death, was meaningless without any explanation as to how that could be assessed, or any evidence as to what, if any, contribution it had actually made. There was therefore no direction that Dalmane had to be more than a minimal cause of death, and no evidence that the amount of either whisky or Dalmane given to Farquhar by Field had been more than a minimal cause of death, and no sufficient direction that it needed to be. By way of conclusion, my Lord, may I conclude with a few words about the academic commentary. The respondent in its RN is dismissive of the academic commentary. The shared theme of the commentary referred to by the CCRC is that this court has circumnavigated, evaded, abandoned, or avoided the law as determined by the Supreme Court. That's the language that's used by, amongst others, Professor Ormrod. So the criticism of this court is not that this court has got the law wrong, which is perhaps an occupational hazard for an appellate judge. Criticism is that, knowing the law, it has chosen not to apply it. That is a criticism that this court has failed in its first duty, to apply the law without fear or favour, to apply the law to all manner of people, including a Ben Field. And that criticism, as I say, comes from, amongst others, Professor Ormrod, whose reputation is as an educator of the judiciary rather than a critic. And had those commentators known of the changes made between draft and final judgments of this court and the reasons, the erroneous reasons given for them, then that criticism might have been more acute. Those academic critics are correct. In March of 21, this court allowed its moral disapproval of what Field had done to deflect it from its duty to apply the law. And the result was that it upheld Field's conviction for doing something that, on the evidence of that night, he did not do, cause the death of Mr Farquhar. And as I say, even a Ben Field is entitled to be convicted for what he has done, according to the findings of a properly directed jury. And that is the reason why this court is invited to allow this appeal. And if I can return finally to the most recent of your Lordship's observations or questions as to whether this court is bound by its previous decision. However wrong, and I'm afraid I'm going to suggest obviously wrong, that decision was. Your Lordship will be familiar with the criticism which Lord Legate made of this court in the opening sentence of his judgment in the case of Hayes and Palumbo, the Libor case. And in many cases, in all cases perhaps, that criticism could be regarded as exceptionally harsh. It wouldn't be harsh if those words had been uttered in relation to the decision of this court to uphold the conviction in 2021. It would be justified. And in those circumstances where there has been clear injustice, my respectful submission to this court is that it shouldn't need to the Supreme Court to tell it that it has been obviously wrong. And our invitation is that this court put what was obviously wrong right in this court.
Thank you, Mr. Jeremy. Mr. Jeremy, just one thing we haven't mentioned is whether and to what extent, if at all, reporting restrictions may be required here because of the possibility that ultimately there might be a retrial.
Yes.
Views will vary on how real that possibility is, but it is a possibility. It seemed to me, at least, that given the high profile of this case and the fact that it's been the subject, I think, of a television documentary or dramatised documentary, whatever it is, it's somewhat unrealistic, probably, to imagine that a jury will arrive at any retrial wholly ignorant of it, and that, therefore, reporting of the arguments of counsel is unlikely to prejudice any future jury, which is very likely to be told something about the history of the case. It may be different so far as any judgment is concerned if it expresses judicial assessments of the evidence, guilt or innocence or anything like that. Different considerations might apply to the judgment. What would you say about that?
Can I come back on the possibility of a partial ban on publication? I have given some thought, anticipating whether, as you say, realistically or not, the possibility of a retrial in this case. And, my Lord, I don't know whether your Lordships are aware of it, but there has been a very large amount of publicity in this case, all of it relentlessly negative. And it seemed to me, therefore, against that background, the reporting of these proceedings would really be redundant and pointless, a ban on the reporting of these proceedings.
Yes.
But as to whether there should be a more nuanced order, I think about it.
Well, I think if the nuanced order might apply to the judgment, but that will depend on what the judgment says.
Yes.
And currently nobody knows what it will say, so we can leave that till later. Thank you, Mr. Jeremy. That's extremely helpful, if I may say so. Very clear.
And if I can be provided with an email address, I'll send you the note.
Yes, that would be very helpful. Thank you. We'll do that. Mr. Perry.
Thank you very much, my Lord. May I just pick up on the point that your Lordship just made in relation to publicity? I respectfully agree that there should be no prohibition on the reporting of these proceedings, and any judgment would have to be considered on its own terms as and when the position then arose. So I don't seek any order in relation to reporting of today.
We're all in agreement. So there is no reporting restriction in relation to this appeal. Whether there will be in relation to the judgment when it's eventually handed down, we'll have to await that event. Mr. Perry.
Thank you very much, my Lord. My Lord, may I begin, first of all, by adopting our written submissions dated the 24th of November last year. That's pages 1801 to 1823 of the court's bundle. I'm not going to go through it and read it out. I know that the court will be familiar with what we've said.
Yes.
But may I just commence with the overarching position as we would advance it before your lordships. First of all, the respondent's position remains as it has been throughout these appeals. The actions of Mr. Farquhar were not autonomous in the relevant sense. This is not a case of autonomous conduct on the part of Peter Farquhar, which is what the case of Kennedy was principally concerned with, and all the academic commentary. There was no free, deliberate, and informed is an important component of the autonomy principle, act on his part so as to break the chain of causation. The learned judge's directions to the jury encapsulated that point. They were clear and correct in law, and by following the judge's route to verdict, the jury must have made findings of fact on the basis of which the appellant is properly to be regarded as guilty of murder, the conviction is safe, and the appeal should be dismissed. I should make clear at the outset that we accept the principles of autonomy and individual responsibility as fundamental to the common law, and we also accept the decision in Kennedy is a starting point for consideration of the analysis. I'll have something to say about Kennedy in a moment, but even Lord Bingham, in his analysis, postulated a more subtle investigation of the facts than has been advanced by my learned friend in the course of his submissions, and I'll explain what I mean by that when we come to look at what the certified question was. And just to foreshadow where this goes, that particular decision of the House of Lords in Kennedy was the paragraph 8 to which my learned friend made reference about couldn't be causative. That was in the context of dangerous act manslaughter. The point about Kennedy, which you have to look at when you're reading it, is that the real question that was being considered was whether there was a dangerous act which had been causative of the death. And it is interesting, as we've made clear in our written submissions, and we'll look at the precise wording of the appellate committee when we come to look at it. But Lord Bingham made clear that when he was answering the certified question, it was not necessarily a straightforward yes or no. Because as is apparent, that the question of causation, in this case as in any other case, cannot be assessed in the abstract and subject to some scientific process. It has to be assessed in its own factual setting, and all the authorities, including Kennedy, an important decision of this court in Wallace, the acid scarring case and the euthanasia in Belgium, all those authorities make clear, and in fact all cases on causation make clear that there is a factual setting. In this case, the appellant's argument, the reference to this court by the Criminal Cases Review Commission and the academic commentators have significantly underplayed the factual context, and I'm going to come on and look at some of the academic commentaries during the course of the afternoon. To use the language of some of the authorities, the appellant was not a mere bystander or a spectator at Mr. Farquhar's death at his own hands. The appellant did not, to use the language also found in some of the case law, merely set the scene for Mr. Farquhar's death by his own voluntary act. The appellant was at all times playing his part in causing the death, both as a matter of common sense, fact, and as a matter of law, both as a but-for cause and as a legal cause, and Mr. Farquhar did nothing to break the chain of causation. Mr. Farquhar's consumption of the 61% proof whisky and Dalmane was not in any sense an autonomous, properly informed act. Quite the contrary. Mr. Farquhar was being used unwittingly as the appellant's instrument to bring about his, Mr. Farquhar's, own death at the appellant's hands. Mr. Farquhar had been deceived and rendered vulnerable over a period of 2 years, and the appellant had noted in his own journal that he had moved into Mr. Farquhar's home address, the address at 3 Manor Park Road, so that Mr. Farquhar could die. Your Lordships know that the journal is available at that particular entry is at page 629 of the Mundell. That the death was the culmination of the appellant's plan is not a promising starting point for a disclaimer of responsibility. Peter Farquhar had been deceived and rendered vulnerable. He had been gaslighted and led to believe he was losing his cognitive abilities. The appellant planned to end his life on that evening, the 25th of October 2015, 2 days before the appellant's 25th birthday, following the change of the will which had taken place on the 15th of September, where the appellant became the outright beneficiary, or the principal beneficiary under the will. He planned to carry out the murder in such a way that he would look like an alcoholic's death, which occurred at a time when he was away from the property. He, the appellant, was absent from the property, or so it was to be made to appear. And we can see from the entries in the journal what the appellant was intending to convey. And I'm going to move on to look at those entries after the short adjournment, but perhaps I could just conclude in these closing minutes before the short adjournment with these two observations. There are a number of ironies and paradoxes about the arguments that have been advanced in this case, not least that the argument that has been advanced to your lordships was not, of course, the principal issue at the trial. The principal issue at the trial was that he was not present, and that it was Mr. Farquhar who must have come across the bottle of whisky and voluntarily consumed the bottle that happened to have been left at the property. That was his case at the trial, and that was rejected, and that is why the focus in the judge's directions was on in relation to his presence. It's also interesting that in the Smith and Hogan commentary on this case, they described it as a case of temptation. It's not a case of temptation, and the academic underplaying of the facts we'll look at a little later. So that's one paradox, that actually what's being argued isn't what was in issue at the case, at the trial. The second paradox about the argument is because of the way the appellant sought to make it appear, is the very argument he relies upon to say, I didn't cause the death. So what is being developed here is an argument that because I made it look as though it was by his own hand, I should be entitled to take advantage of the difficult issue of causation, because the respondents simply focus on whether it was an informed decision when they're considering the principle of autonomy. And I'm going to come on to look at some of the facts and look at some of the authorities and some of the principles. And if that's a convenient moment, my lord, I'll come on to deal with that this afternoon.
Thank you, Mr. Perry. Yes, it is. And we'll resume at 2 o'clock.
Thank you very much.
Thank you very much.
Later, at 628, your lordships will see in the bottom third or quarter of the page, preempt, Peter will not take action, but expose self to risk, and then an arrow, medication, call 999, establish history of this. What was going on here was to give the appearance of a problem with Mr. Farquhar, so that when he did eventually die, it would be put down to his own hand. And we can see that expressly at 629 of this same journal, which I hope your lordships have, on the top left-hand corner, that section there, I hope your lordships see, will change instigates death by his hand. So the will change, it went through a number of changes. It was eventually changed on the 15th of September. And also, further down that page, I moved in so he could die. So that was the whole plan. And also on that page about funeral speech, can we have a suicide note? And what happened was, if your lordships go to page 631, it became apparent that despite the appellant's efforts, it became clear that Peter, Mr. Farquhar, it became clear that he suicides not. So there was the he suicides not entry. And later in the journal at 641, your lordships can look at this in detail after the hearing, but these are just some of the highlights. At 641, your lordships will see at the top of the page, port in wine bottles. So that was going to be sort of putting a strong drink in a wine bottle. High alcohol cocktails, for example, 65% gin, cherry brandy, high alcohol single malts, and then in the middle of the page of this extract, chocolate Dalmane, and also at the bottom of that page, there's the entry which featured at the trial and had some prominence at the trial: suffocation, only a mistake if either survival or evidence ensue. Feed Dalmane and more alcohol and less air. So that's the entry. And then 645 is references to the gaslighting, and 650 is another reference to Dalmane plus alcohol at the top of the page, and also the reference in the middle of the page that a loss of capacity would involve a long wait. It says loss of capacity and long wait. So, and then 655, we have another reference to Dalmane and chocolate, and also a reference to strap, which was the appellant's word for suffocation, and the possibility of falling downstairs and being overwhelmed with despair. And at 660, the appellant makes a note in his journal that he'd become amazingly promiscuous in the matter of death. So there was sort of part of the background of what actually was going on, and what the night of the evening of the 25th of October actually was the culmination of. And it is against that background that we then move to Professor Glanville Williams, who was so influential in Lord Bingham's seminal opinion in the Kennedy case. And if I may just invite your lordship's attention to 895 of the bundle, which is where Professor Glanville Williams' Cambridge Law Journal article in 1989 is to be found. And the important points of principle are, first of all, on at page 895, a person is primarily responsible for what he does and not for what other people do. And then he deals with the but-for test and the distinction between the doer of the act that intervenes and the final wielder of human autonomy. So that's what this is driving at, the act of will, which is represented in a society such as ours by the freedom to make choices and act on an informed basis. And then at page 896 is his discussion of the novus actus interveniens principle, because he says the autonomy doctrine, expressing itself through its corollary, the doctrine of novus actus interveniens, teaches that the individual's will is the autonomous, self-regulating prime cause of his behavior. And then he says it may sound metaphysical, but it accords with our ideas of moral responsibility and just punishment and serves social objectives. So what Professor Glanville Williams is driving at is the alignment between some causal connection and moral responsibility. In other words, as it's sometimes expressed in the academic literature, the causal bridge. And I'm going to explain what we say about the causal bridge in a moment. But if we may just sort of see what Professor Glanville-Williams has to say, because what he says is the first actor who starts on a dangerous or criminal plan will often be responsible for what happens if no one else intervenes. But a subsequent actor who's reached responsible years is of sound mind, has full knowledge of what he's doing, and he's not acting under intimidation or other pressure or stress resulting from the defendant's conduct, replaces him as the responsible actor. And this is what this is why Lord Bingham modified the certified question in Kennedy, which was the straightforward question about the intervening actor. But Lord Bingham qualified it because, no doubt influenced by Professor Glanville-Williams, there's the responsible years of sound mind and full knowledge of what you are doing, and not acting under pressure or stress resulting from the defendant's conduct, and that responses him as the responsible actor. And that breaks the moral connection that would otherwise have been perceived between the defendant's act and the forbidden consequence. An intervening wrongful omission does not break it. But Lord, I ought just to mention one other part of this article, because it's relevant to some of the academic commentary, and I'm just going to explain why it's relevant and where it is. The relevant part of this article is at page 913 of the bundle. This is later in the article when Professor Glanville-Williams has been discussing the draft criminal code, which he had a number of things to say, but then he makes reference to two authorities at page 913. Malcherek was the brain death case where you switch off the life support machine, and Paget was the police shield case. So Malcherek is the brain death case, Paget is the shield case, whereby the police shooting at Paget killed the person who was the shield, and Paget was held responsible for the death. He caused it in a relevant legal sense. And what Professor Glanville-Williams goes on to say is the reasons offered by the court in Paget, and we'll look at the reasons in a moment, but just for your lordship's note, it's Lord Justice Robert Gough, so it couldn't really be any better. But the reasons offered by the court in Paget proceeded on the basis that the police were acting in self-defense, but the more obvious justification was that they were entitled to shoot at a suspected violent offender if this was reasonably necessary to escape or to prevent violent crime. On any view, the police acted under the pressure caused by the defendant and so were not exercising the unfettered volition presupposed by the Novus rule. Now, that expression, or that phrase, unfettered volition, was used by the Court of Appeal in Wallace and has been the subject of academic criticism, because the academics say, where did that come from? The Court of Appeal have invented another wheel for the coach. But in fact, it's just another way in which Professor Glanville-Williams expresses the basis of the autonomy principle, so unfettered volition. It's driving at the same point, and it's significant that it's made in respect of, or it's expressed in the context of discussing Paget, because your lordships have the decision in Paget. I've finished with the Professor Glanville-Williams article, but I'm going to come to Wallace to where those where that appears. But I'm going to turn to Paget, if I may, to see what Lord Justice Robert Gough did have to say about Novus Actus principles. And your lordships have the authority of the Court of Appeal at page 2024, and at 2033, of the bundle is the judgment of the court. As I mentioned, it was a case, the Human Shield case, where the police officers were shooting at the appellant who'd taken a human shield as hostage. And at 233, in the bottom half of the page, Lord Justice Robert Gough begins his discussion about it's really necessary to give the jury any direction on causation as such. And he goes on, usually there are other issues in dispute. But then partway through down the page, if I may pick up where he says occasionally, because this is...
Mr. Perry, I'm just looking at this in the report, which I've got separately and have been looking at.
It's 288.
288, thank you very much.
288 of the internal page numbering.
Yep.
And your Lordship knows that this was Lord Justice Robert Gough discussing the specific issue of causation and how it may arise. And he says one such case is where, although an act of the accused constitutes a causa sine qua non, or necessary condition for the death of the victim, nevertheless, the intervention of a third person may be regarded as the sole cause of the victim's death, thereby relieving the accused of criminal responsibility. And then this is the critical part. Such intervention, if it has such an effect, has often been described by lawyers as a novus actus interveniens. We're aware that this time-honoured Latin term has been the subject of criticism. We're also aware that attempts have been made to translate it into English, though no simple translation has proved satisfactory, really because the Latin term has become a term of art which conveys to lawyers the crucial feature that there has not merely been an intervening act of another person, but that act was so independent of the act of the accused that it should be regarded in law as the cause of the victim's death, to the exclusion of the act of the accused. And then, rather teasingly at the end of the paragraph, he says, at the risk of scholarly criticism, we shall, for the purposes of this judgment, continue to use the Latin term. Well, my Lord, what we submit is the principle that's to be taken away from this is what all the authorities speak of with one voice, and which is undisturbed by Kennedy. This is a pre-Kennedy case, but it's still, nevertheless, the principle. Is the act so independent of the accused that that act, rather than the act of the accused, should be regarded in law as the cause of the victim's death? Now, in this case, everything that took place in relation to the death was in no sense independent of the act of the accused, because it was, in truth, implementing the plan of the appellant. And that is why the issue of causation really did boil down to, was he present and did he give him the drink? Because that was the plan that he was implementing. Now, the point that is being made to your lordships is, well, that's not good enough, because giving having full regard to the principle of autonomy, the appellant's acts are relegated to causal history and have no causal relevance to the case at all. And in fact, on the appellant's case, it's arguable the case should not have been left to the jury. What we submit is Mr. Farquhar was in no sense autonomous or acting autonomously. He did not know that he was in fact participating in the very transaction that was intended to extinguish his life that very night. And that is why the appellant's conduct is causally related. There is no break with the factual or moral connection, as discussed by Professor Glanville-Williams, between the appellant's acts and the forbidden consequences. And whether you look for a but-for test or a legal test, in every relevant sense, the appellant brought about the death. We also note that in the decision in Wallace, which is also in the authorities bundle, I can now draw your lordship's attention. It's at 436, and I don't know if your lordship has it separately, but I'm going to go. This was the attack with acid that caused the victim, injured by the corrosive substance, unbearable and constant pain, and he applied for euthanasia and was killed by a doctor in Belgium, where euthanasia is lawful. And the question was whether the act of the doctor was a new intervening act, a novus actus interveniens, so as to break the chain of causation. And even in this case, the Court of Appeal held that that issue could properly be left to the jury. And if I may just identify where the free and unfettered volition comes in, if I may just invite your lordship's attention to paragraph 61 of the report, first of all. Paragraph 61, which is in the criminal appeal reports, is at page 341, and in the bundle at page 452. Your lordships will see, although it's not in quotes, that there is a reference to whether the acts of the individuals were the product of the sort of free and unfettered volition presupposed by the novus actus rule. So that's effectively a straight lift from Professor Glanville-Williams. So it hasn't come from nowhere. It has come from Professor Glanville-Williams. And similarly, at paragraph 76 of the report, the Court of Appeal also talk about the sort of free, unfettered volition presupposed by the novus actus rule. So it's the same language that you find at 63, and it's also the language from Professor Glanville-Williams. So this is all consistent with the autonomy principle. But even in those extreme circumstances, which are very, very far removed from the case before your lordships, it was held by the Court of Appeal that the issue of causation remained for the jury, because it was open to the jury to conclude that the original attack was, or continued to be, an operating more than minimal cause of the death. And the Court of Appeal made it clear that these involved, because we have jury trials, common sense questions being put to juries in the most helpful way that is possible. And Wallace is a helpful authority because even with the intervening act of the doctor in Belgium, that was not sufficient necessarily to break the chain of causation. It was a matter that could be left to the tribunal of fact. Now, one of the criticisms of the Wallace decision is at page 884 of your lordship's bundle, and it's by Professors Semester and Sullivan, who have also criticised the decision of the Court of Appeal in the instant case. And your lordships will see that in their commentary on Wallace at 884, and this is in the Law Quarterly Review in January 2019, it's a note on the case of Wallace. And at 885, there's reference to Paget and Lord Justice Robert Goff, and then coming down the page, it's settled law that the accused act need not be the sole or even the main cause of the death. For causation to be established, however, an uncontroversial principle like this does not take us very far. It does not tell us what it takes for D's act to be a cause. It offers no guidance. And then it discusses the facts of Wallace. And then at 887, in the middle of the page, it says, it makes reference to the intervention must, it seems, not only be free, but also unfettered. And there's reference to Kennedy. And the point that's being made is that the Court of Appeal had introduced the concept of fettered, and your lordships can read that and probably have read it and will read it again. But what the commentators go on to discuss is what they call the FDI, the free, deliberate, informed issue at 888. And what they go on to discuss, going on to 889, is the type of causal connection that is being looked for. And your lordships will see at the very end of 889, it's almost the very end of the case note. Can we, in other words, construct a causal bridge from D's act to T's? That's the doctor in this particular case. Kennedy confirms that if T's act was free, deliberate, informed, the answer to the question is no. Only if T's act fell outside the scope of the free, deliberate, informed should we proceed to ask whether the intervention was reasonably foreseeable and not extraordinary. Well, that's the academic commentary, but so far as directed at the Wallace case, the case before your lordships is a less extreme. It's an unusual case, to be sure, but there is, in this case, to use the professor's own language, a causal bridge. So we say that, and there isn't the new intervening cause of the type that the authorities, such as Paget, explained by Lord Justice Robert Goff in Paget, identify. So, in the appellant's case, our submission is there was no act independent of his conduct. And in fact, all the appellant's acts were relevant as part of the background when it came to assess what had actually happened on the night of the killing. The moving into the property, the exploitation, the gaslighting, the change of the will, the thoughts expressed in the notebook. And it's also relevant for your lordship's consideration that in advance of the trial, the appellant pleaded guilty to a count on the indictment, count 2, which was fraud in respect of the will. And if I may just, so that your lordships have the significance of it, it's just to make the point. It's at page 308 of the electronic bundle. It was count 2 of the indictment to which the appellant pleaded guilty, and the false representations which were laid between the 22nd day of April 2013, which was just before he moved into the property, and the 27th day of October 2015, which was the day after Mr. Farquhar's body had been discovered on the morning of Monday the 26th. But the allegation was that dishonestly and intending thereby to make a game for himself, he'd made representations to Mr. Farquhar which he knew were or might be untrue or misleading, namely that he was in a genuine caring relationship. And that was all false. The whole basis of the relationship was entirely exploitative from the appellant's side. That was his plan from the outset to exploit, and the dishonest representations are relevant to how we are to look at the issue of causation when it comes to considering what took place on the occasion of Mr. Farquhar's death. So significantly, the appellant was present at the property at the time of the killing. That was actually the issue at the trial, as I said before the short adjournment. And there was also evidence that after the killing, he had made notes that were also incriminating as to his presence. And if I may just, it's difficult to read because it's in manuscript, but the page reference in the electronic bundle is at page 538. And it's only this. There's an entry there which says, in the middle of the page, but it's dealt with in the summing up at page 123, the defendant was making a note that Peter's death had taken place on Monday, quotes, 26th. So the 26th was in quotes. And of course he knew the death had taken place the evening before, on the 25th. And also, significantly, the appellant composed or compiled or authored an unpleasant eulogy in which he made reference to Mr. Farquhar, quote, went unpardoned and petrified. That is in the JAA section of the DCS. It's Exhibit Section J, page 73. So there was evidence that, on one view, he was saying that he went, Mr. Farquhar's death is being described as unpardoned and that he was petrified. So these are not the indications of a new intervening act that relieves the first actor of causal responsibility. These are notes explaining how the appellant, in fact, put into effect his plan to cause the death, and he did so. Your Lordships also know that he disposed of a quantity of whisky, the appellant disposed of a quantity of whisky from the bottle that he'd taken to the house in order to make it appear that Mr. Farquhar had consumed far more than had in fact been the case, and to bolster the impression that he had drunk himself to death. So that was the part of the plan to give the appearance that he had consumed more of the drink, and it was, in effect, a form of suicide or accidental death through excessive intoxication. But the evidence was that the drink and Dalmane were sufficient to cause death in themselves without suffocation being necessary, and your lordships know there were no visible signs of smothering by the time the second post-mortem had taken place in 2017, and the pathologist could not rule out smothering, but nor could he rule it in. So it was on that basis that the case had to be left to the jury. So the position was that by the time of the summing up, there was compelling evidence that the appellant intended to kill by suffocation if necessary, and Mr. Farquhar had no idea that the plan was that he should die that very night. And the case was then left on the basis of the possible routes to death, the drink, drugs, and suffocation, but they are not to be regarded as distinct alternatives. They were part of a single plan which began with the trail of misinformation to suggest that Peter Farquhar had become a suicidal alcoholic. And your lordships may also be assisted because there was the table of showing the administration of drugs and their effects, which is at page 683 of the Court of Appeal electronic bundle. And this is the table which correlates the entries in the appellant's diary and Mr. Farquhar's journal. And just in answer to my Lord's question this morning, my Lord Mr. Justice Goose asked about the Dalmane, just so that your lordships are aware, in the table in the BF diary column, the reference to Fluoras is actually the reference to the name of Dalmane. Dalmane is its trade name, or
sleeping tablet, isn't it?
Yes, exactly, Lord. So we can see by looking through that when it's given, and it's also apparent from what the defendant was saying that he was administering that covertly, and that together with the gaslighting, as he put it in his journal, was causing significant distress to Mr. Farquhar, as he recorded in his own notes. So that gives an indication of the administration of drugs. It wasn't suggested that it was necessarily entirely complete, but it was all consistent with the prosecution case as presented to the jury. And what we submit is that the learned judge's directions, which we've actually set them out in our submissions, and I don't need to turn to them unless your lordships wish me to. But we submit that the directions given to the jury and the judge's response to the jury's questions encapsulated accurately and concisely the issues which the jury had to decide. And in fact, the autonomy principle in this case was encapsulated by the information which Mr. Farquhar did not have as to what it was, the transaction in which he was actually playing a part, whatever may in fact have gone on between them at that address where only they were present. So far as Kennedy is concerned, if I may just turn to the decision in Kennedy, because we submit that everything that we have submitted is consistent with the decision in Kennedy, and the decision of the House of Lords is at page 464, and the important points to note are, first of all, the certified question at page 465 at the bottom of the page, which is at page 270 of the report, if your lordship is using the report. And it's at the bottom of the page.
I'm sorry, I'm just using a report which has paragraph numbers. So.
I'm sorry, my lord, it's before you get to the judgment, because it's actually after the head note, and it's the explanatory how it comes to be before the appellate committee.
Yes.
And your lordships can see the certified point of law, and it wasn't answered categorically because it's qualified. It's a qualified response. But first of all, when is it appropriate to find someone guilty of manslaughter where that person has been involved in the supply of a Class A controlled drug, which is then freely and voluntarily self-administered by the person to whom it was supplied, and the administration of the drug then causes his death? So, in fact, this was, as we will see, a dangerous act manslaughter case, and sort of Lord Bingham sets out the certified question, at paragraph 2 as well, and then sets out the facts. And the paragraph to which my learned friend made reference this morning, paragraph 7, the act of supplying without more could not harm the deceased. This paragraph 7, your lordships will note, is in the context of the crime of unlawful act manslaughter. So that's the context. And Lord Bingham is addressing the question of whether there was an unlawful and dangerous act. And that's why he says, let alone cause his death. The supply of drugs would itself have caused no harm unless the deceased had subsequently used them. So he's addressing whether you've got the unlawful act for the unlawful act manslaughter, and that's why he goes on to discuss at 8 that the parties were agreed that an unlawful act of the appellant on the present facts must be found, if at all, in section 23 of the Offences Against the Person Act, which is the malicious administration of poisons, etc. Then he goes on at paragraph 14 to identify the autonomy principle, relying on Professor Glanville Williams's article and Hart and Honoré in their work on causation, and normally held to relieve the first actor. And he goes on to discuss how it's these principles are fundamental and not controversial. He then goes on to discuss a decision of the House of Lords on a statutory construction point where causation was didn't depend upon the act of a third party. And then what he goes on to do, having considered the law at 25, is the answer to the certified question is, in the case of a fully informed and responsible adult, never. So Lord Bingham is introducing qualifications. In a child, it may be different. In the case of someone who's not fully informed, it may be different. But if you're fully informed, and assuming you have all the information and you have capacity and responsibility, then the law respects the autonomy principle. But that is subject to what we've been discussing in this case, which is Mr Farquhar was anything other than informed as to what was going on. And in the same way that Lord Bingham qualifies his response to the certified question, that's also what motivated the Court of Appeal in Wallace to approach the question in the way that it did in relation to causation, and it's what motivated the Court of Appeal, the first Court of Appeal decision in the appellant's case, which we respectfully submit was correct. There's just one thing I just want to. There are just before we turn to the Court of Appeal decision, also in the authorities.
Could I just ask you a question about Kennedy, which is Lord Bingham says, as you've just pointed out in paragraph 25, in the case of a fully informed and responsible adult, never. But does one gather what Lord Bingham meant by fully informed from paragraph 18, where what he says in the last sentence is the finding that the deceased freely and voluntarily administered the injection to himself, knowing what it was, it's fatal, etc. That is certainly one of the readings which people have given to Kennedy, yes, which is that he was there defining effectively what he meant by fully informed, which is that you've got to just know what the thing is.
Well, my Lord, it's not just knowing what the thing is, because it's information that's going to ensure that there is a new intervening act. And when Lord Bingham in paragraph 18, part of the issue in this case was that the certified question was premised on the basis that it was that case that he knew. But you can easily modify the circumstances, and Lord Bingham's answer would no doubt take into account the subtleties and nuances that would apply in a particular case. That's why questions of causation are intrinsically fact-specific, and it's why you're looking to align the legal cause and the moral responsibility. That's what this is about, because Lord Bingham, together with Professor Glanville-Williams and Professors Hart and Honoré, are identifying a principle which has been a principle of English life since about 1688. So it's the Enlightenment idea. You're autonomous, and you take the consequences of your own free choices. But if your free choice is procured in some way by some important absence of information, then you're not within you're not within this rule.
Thank you.
And then it's also relevant because the Supreme Court looked at causation in the Hughes case in a different context, but that's at page 420, and at paragraph 20 is the concept of causation, heavily context-specific. In this case, that's of course directed at the particular statute. Lord Bingham acknowledged as much when he was discussing Lord Hoffman's decision in the Empress case. But here the Supreme Court is noting the possibility of a break in the chain of causation. And at paragraph 23, there is discussion of the well-recognized distinction, and this is important, in the case law. Then this is what really Wallace is drawing the distinction between, and also what the Court of Appeal in the decision under appeal were distinguishing. In the case law, there's a well-recognized distinction between conduct which sets the stage for an occurrence and conduct which, on a common sense view, is regarded as instrumental in bringing about the occurrence. So there's there's the helpful review of some of the English and Commonwealth authorities with Chief Justice Mason in the High Court of Australia, sort of talking about the exclusion of the common sense approach, which the common law has always favoured, and that ultimately the common law approach is not susceptible to a formula. Now, that's not to say there aren't principles, but it's to sort of recognise that you're trying, as the Court of Appeal in Wallace recognised, you're trying to ensure that there is the necessary legal cause, and we address the decision in Wallace in our written submissions at paragraphs 29 to 31, page 1810 to 1811 of the electronic bundle. I won't take your lordships to it. And I want to very briefly turn to the decision of the Court of Appeal in the first appeal. And may I, for these purposes, it's page 1763. Just before I consider it, my lord, may I answer the court's question from this morning about stare decisis and where we are in the doctrine of precedent? Because although Young and Bristol Aeroplane is still the governing authority, it is the case that in the criminal division there has been a degree of flexibility, and we'll make sure that your lordships have a note dealing with this together with the references. But Lord Justice Diplock dealt with this question not on a reference from the CCRC, because it predated the existence of the CCRC, but in a decision called Gould, G-O-U-L-D, which is 1968 to Queen's Bench Reports at 65, at page 68, where he talked of a degree of flexibility that is not available to the Court of Appeal Civil Division. But that's not to be taken too far, because there's also a decision of Lord Justice Clark called Grant, 2003, which again we can provide your lordships with the reference, but it's EWHC 130, 2003 EWHC 130 admin, where it was suggested that it would not be conducive to legal certainty or the orderly disposal of legal business if courts could just second guess earlier decisions. So there has to be some good reason for departing from an earlier decision, and my lord, we would say that that principle applies equally on a reference from the Criminal Cases Review Commission. And your lordships have some flexibility, but and Parliament has recognised through the ability of the CCRC, the Criminal Cases Review Commission, Parliament has recognised through the ability of the Criminal Cases Review Commission to refer cases back to this court on the same grounds, the fact that there must be circumstances in which the court would say, well, the earlier decision was per incuriam, although that wouldn't be binding in any event, where you could just say, well, it went wrong. But what we would submit, my lord, is that the Court of Appeal decision in this case, despite all the criticisms that have been directed to it, was actually correct. And the
Mr. Perry, just before we leave stare decisis, if we're about to, my memory is that in the Court of Appeal in Hayes and Palumbo, the court set out all the current rules, so far as they're understood, about that, including the degree of flexibility. And I don't think that the Supreme Court doubted any part of that. I don't think they mentioned it, actually.
Yes, I think your Lordship is right. The Supreme Court didn't mention it. The only point the Supreme Court were making was that perhaps there weren't sufficient, that perhaps points of law of general public importance weren't being certified as often as perhaps they might be, given that we have a court of final appeal that has a criminal jurisdiction, unlike Scotland, where the criminal courts are the final court of appeal in Scotland. But, my Lord, we'll provide your Lordship with the decision of the Court of Appeal in Palumbo and Hayes as well. But what we would submit, Lord, and I make these submissions with diffidence and respect to the Court of Appeal. There are two parts of the Court of Appeal decision, and when your Lordships are considering the merits of the instant case, we would just invite your Lordships to bear them in mind, because it's what's prompted some of the academic criticism, and it may be that it's not a change of substance at all. But in paragraph 59 and 60, which is 1777 of the bundle, at 59 is the reference to the weak swimmer example, which is correct. We respectfully agree the weak swimmer example is a good example because of the uninformed state of mind as to the real intention. And then the Court of Appeal says would have changed the nature of the undertaking on which the victim embarked by rendering it more dangerous. The way that we would express it is that the uninformed state of mind means that it's, the autonomy principle is simply not in play, and what is taking place, Mr Farquhar's involvement in what is taking place, which was dangerous because of the drink and the covertly administered drugs, was simply uninformed. And that's also in 60 to say that the undisclosed intention substantively changed the nature of the undertaking. What the Court of Appeal were driving at, we would respectfully submit, is that the undertaking upon which Mr Farquhar embarked was not what he understood it to be, and he was not informed. So, so we just make those observations for your Lordship's consideration, bearing in mind that there will be a reasoned decision in this case. But we submit that the Court of Appeal correctly analysed the facts, they went into the background, they correctly analysed the autonomy principle and made reference to Kennedy, and they also found that the judge's directions had encapsulated the absence of being informed, the absence of any information that meant that what Mr Farquhar was doing was done on an informed basis. So there was and is no intervening act so independent of the Appellant Act that should be regarded in law as a cause. We've set out in our written submissions our response to the grounds of appeal, and I can deal with the points, I hope, quite shortly, adopting what we say in the written submissions. I ought to make these points in response to my learned friend's submissions before your lordships this morning, we do not accept that the Act is limited to ingestion, that's to take far too narrow a view of the autonomy principle, and knowledge of what he was consuming and who was giving it to him is not sufficient in these circumstances to amount to a break in the chain of causation. And of course, knowledge of the act and the identity of the person is a direct lift from the sexual offence consent cases, and the point about consent in the criminal law and in sexual relationships is that consent is a highly complicated issue because of the nature of human interaction. The law has to be very careful where it draws the lines, and consent in sexual relationships is not a proxy for causation in causing death. It's got nothing to do with it, and the cases about consent are simply about the meaning of consent, and that is why they don't feature in any of the cases to do with causation. So we invite the court to reject the consent argument. In relation to the fact that the direction was principally in relation to drink, it focused on the drink, we would respectfully submit that's more favourable to the appellant, because it meant that the jury had to be sure that it was the giving of the drink that was the cause in a legal sense of the death, even though the overwhelming inference was that Dalmane had been administered covertly.
The pathologist's opinion was that the only available cause to be found on post-mortem examination was the combination of alcohol and the sleeping pills, because between them they were both suppressants.
Yes.
That was the conclusion, so that was the evidence.
Yes.
So why then simply leave it to the jury to decide, if that's what happened, that the cause could amount to the taking of drink only, rather than drink and drugs, rather than drink or drugs?
Well, my lord, what I would say in relation to that is it doesn't matter, because if you've got one of them in and the jury follow those directions and they conclude, then that's sufficient. It could have been that the judge could have said drink, Dalmane, and both, but the jury was satisfied, and in the end it's the jury question in relation to that. But it's not an error adverse to the appellant, because it's focusing on one aspect of what he did. And it may be that, I wasn't there, of course, but it may be, I mean, the overwhelming inference was that Mr Farquhar had not actually self-administered any Dalmane. Why would he? Early in the evening, when he thinks he's with a friend who's keeping him company, little knowing that what in fact is going on, and the fact that this is all part of a transaction which is designed to kill him that night, and that the appellant will then make himself scarce so that it appears as though he wasn't present. So the directions do encapsulate the important part of the prosecution case, and they simplified it for the jury, as the Court of Appeal noted. So, and then, if I may just turn to some of the academic commentators, just very briefly, if I may, because your lordships know that I foreshadowed this morning that the academic commentaries are not, they don't sufficiently engage with the particular facts of this case. And the first one is the deadly whisky article, which is at page 1189. And your lordships will see at 1190, I'm not going to go through all of this, but in the middle of the page, V was the author of his own demise, and D was not guilty of murder. And towards the bottom of the page, in the bottom quarter, the end of the main paragraph, it's difficult to reject the conclusion that V killed himself. And then they, at page 1191, they deal with the weak swimmer example and seek to distinguish it. We would respectfully submit in an unsatisfactory way. But the key point to take away from this article is towards the bottom of the page, where they encapsulate in a modern form what used to be "we're not our brother's keeper," which they encapsulate as "we're not our fellows' keepers." Well, Lord, we would respectfully submit that, yes, that's right so far as it goes, but it's wrong to say we're not our fellows' keepers if, in fact, over a period of 2 years, you've embarked on a plan which is going to end up in the death of the person for whom you have to whom you've represented you are a loving and caring friend. And this simply does not give adequate content to the factual bases upon which this case was presented and the evidence as it was before the jury. So that's what we say in relation to that. The next article, which is on novus actus interveniens, makes clear that in the first paragraph, what the Court of Appeal decided about the uninformed nature of the decision, and that the verdict was understandable, but the author says there's an alternative, a more principled basis for reaching a verdict on a sort of duty principle. The other authority, involuntary voluntary action, is also a discussion in relation to the autonomy principle. And again, we make the same observations in relation to it. And when your lordships come to read it, with our submissions in mind, we make the point that if your lordships, for example, look at page 1200, 1200 in the first main paragraph, in Field, the defendant was pinpointed as the wrongdoer of murder, but the issue is what was his doing for which he's been held accountable. This seems to suggest that Field should not have been criminally responsible, as he only supplied the whisky, but the appeal focused on the voluntariness of the victim's actions in drinking the whisky. This was though even there was no suggestion the victim had been forced to drink, and it was accepted at trial that it was his choice. So, but that is to ignore the fact that the informed basis of the choice was what was for the jury's consideration. And in Smith and Hogan and Ormrod's criminal law, which is at 1206, your lordships will see that at page 1207, there's reference to the decision under appeal Field and Semester and Sullivan, not our fellows keepers, and your lordships will see that at the top of page 1207, D left a bottle of strong whisky out to tempt V. Well, that's actually not the case. That's not the case. It wasn't left at the property. He was there giving the drink to V. It wasn't the defendant's case was that Peter Farquhar must have found it and been tempted to drink, as opposed to him giving him drink. So,
what difference does that really make on your submissions? If effectively Mr Farquhar was deprived of autonomy by the fact that he didn't know about the scheme and that he wanted to die, that he was wanted to die that evening, what difference does it make if Mr Field had left the bottle out with the intention that he should drink it, or his being there and giving him the glass?
yes, well, my Lord, that would raise a different causal issue, because you then have to explore the nature of his vulnerability and what the position was. But it wasn't the case as it was being put, and that it may be in certain circumstances, my Lord, that would be that there would be a proper causal connection, but that would depend on all the facts. But if you'd, I mean, it wasn't the case here. It's not the way the case has been left. But if there is some sophisticated plan to snare someone in that way, well, a jury might well ultimately conclude there's the causal bridge, because you haven't relegated it to causal history. It's still the operating cause of death. And that's why in the Kennedy case, although he was an addict, it was the free voluntary assumption of the risk of taking the drugs that was critical. But if you have yourself been rendered vulnerable such that you crave it and you've been rendered into a state of dependency, it might be different. So, my Lord, the point I'm making for present purposes is the academic commentary isn't necessarily to be taken, and ultimately, of course, it's academic commentary as opposed to binding authority. But, my Lord, we as I made clear, we've set out our submissions in detail, and I hope I've dealt with the points that were raised by the court during the course of legal argument. We will, of course, provide your lordships with a short note on precedent, and unless there's anything further with which I can assist your lordships, those are our submissions.
Thank you very much.
No, thank you, Mr. Perry. That is very helpful.
Thank you.
Indeed. Thank you. Mr. Jeremy.
A few very short points, my Lord. Firstly, in answer to Mr. Justice Butcher's last question, the answer is it would make no difference whether the giving was by leaving a bottle or pouring. It could arguably still be giving, and that's why the distinction that the learned trial judge drew when explaining to the jury the directions, this is at item 5, page 176, emphasizing that Field had to be present in person, is redundant, because if the case is being put on a concept as broad as giving, that would cover pouring, leaving it behind for Mr Farquhar to assume, and that's why the answer to your Lordship's question is it would make no difference. And that is why the distinction that Mr Justice Sweeney was at pains to make, because, as he said at letter F on page 176, the difference is because it's not the prosecution case. They don't put it that way and they must prove their case. He's not addressing a point of principle there. And the prosecution, all the prosecution have to prove is that there was an act of giving. That perhaps illustrates some of the, if not confusion, lack of clarity that had crept into this case. Secondly, can I correct one matter of fact? Recently in his submissions, my learned friend said that the overwhelming inference was that the Dalmane was not self-administered. In fact, to the contrary, the overwhelming inference drawn from the evidence was that it was self-administered. First of all, the evidence in the summing up, I will give the references to it, but the records of both men were consistent and the jury were invited to accept them as accurate by Mr Justice Sweeney, that the drugging had stopped 3 weeks before, corroborated by the evidence of multiple friends who'd seen the improvement, corroborated by the forensic evidence taken from the hair samples. Second point, what the prosecution said in opening, both in the opening note and in the actual transcript. The prosecution did not assert that that was the overwhelming inference, that it was not self-administered. They, in the passages I've referred you to, conceded that it could have been taken voluntarily.
But if the prosecution could prove that the Dalmane was covertly administered, that Mr Farquhar didn't know he was having Dalmane, this would be a very simple case.
Absolutely, my lord.
Because the evidence was it was a partial cause of death.
It would be within all fours of Lord Bingham's example, precisely, and it would have been the ignorance of Mr Farquhar as to the nature of the act of consumption.
Because you'd never have to think about Mr Field's intention, because the question of informed never arose. He didn't know he was having it.
Well, you don't have to think about Mr Field's intention anyway, because it has no relevance to...
No, I know, but that's your point. But the reason why the intention is in the directions and in the judgment of the Court of Appeal is precisely because the prosecution couldn't put, or at any rate the judge didn't leave, the case simply on the basis that this was Dalmane, which was smuggled into his system and was a partial cause of his death.
Absolutely right. This would have been a very straightforward case if there was evidence of covert administration. The third point, though, my lord, on the question of why Mr Perry was wrong to say what he did, is, of course, that it was a therapeutic dose. Why would, if this was administered covertly 3 weeks after the organised drugging had stopped, why would Field administer a therapeutic dose covertly? So for all of those reasons, the overwhelming inference is, in fact, that it was self-administered. Lord, are there any other matters that you would?
No, thank you, Mr Jeremy. Very well, thank you both, and everyone else on each side who has contributed to the excellent submissions that we've received, both orally and in writing. The case is complex, and we will have to reflect carefully both on our decision and also on how we should express it, and therefore we will reserve judgment as we said we would at the start of the proceedings. We shall look forward to the note that we've been promised by Mr Perry and anything further on that subject, Mr Jeremy, that's to say stare decisis, the relevance of the CCRC referral to that you wish to supply us with, because that arose as a result of questions from the court. We look forward to that and won't hand down a judgment until we have received everything. If you decide you don't want to lodge anything, would you let us know so we won't wait for it? We will hand down a judgment in draft, subject to the usual embargo. This case has obviously attracted a good deal of attention, and the embargo is of particular importance, and we expect that it will be honoured, and failure to do so is, of course, a contempt of court. The purpose of handing it down in advance, or rather sharing it in advance of handing it down, is simply so that counsel can assist us by correcting typographical and obvious factual errors which the draft may contain, and nothing else, except that it will enable the parties to consider what consequential order might be made as a result of whatever decision we reach. There was discussion of the possibility of, at some stage, certifying a point, which no doubt may arise, whatever the outcome, and whoever wins, whoever loses. It would be of interest to us to see the point that the Court of Appeal declined to certify in 2001. I don't think we've got that, but if records contain it somewhere, it would be of interest to have a look to see what it was that they were asked to certify at that stage. So thank you very much. We will endeavour to hand down the judgment as soon as we can, but there's a good deal of work involved in it, and we can't promise that it will be imminent, but we will do what we can.
Is your Lordship able to give even the roughest of rough estimates when you will aim to?
Well, I can say that we always hand down judgments within 3 months of the conclusion of the hearing, and that will certainly happen in this case. So I can give you that much, but not much more, I'm afraid. Thank you.
Court rise, if able.